Spark, Lord, I have effected. So far as injunction application is concerned, since
I am appearing for the respondent.
admission, my lordship, I've been asked to serve the notice.
Yes. Where is the service? It's complete.
So they are
I
making.
am appearing. I have filed
You are
local.
appearing?
On 19th September 2020.
Can is an injunction or?
Injunction, my lordship.
Give me a minute, please. Yes.
Lord, I'm the plaintiff before the trial court. My suit for partition simpliciter was dismissed, holding, Lord, that the defendants have acquired right title based on a will. First appellate court I lost. This court, Lordship, while admitting the appeal on 19th September 2023, two substantial questions of laws were formulated. Lord, since should be the partition suit and I'm being the daughter's Lordship, Lord, I'm having the apprehension, Lordship, that during the pendency, they would create a third party interest, but they have to be restrained with an injunction order, for which this injunction application has been taken off, Lordship. Lordship, appeal can be expedited, Lordship. I will go with the paper book formalities, but till such time, some protection for a limited period may kindly be. Otherwise, Lordship, what would happen if during the pendency they creates third party, Lordship, it would lead to legal complications.
Let us hear the response. Yes.
My lord, first thing is that the property is recorded in my name. And I have notification has been carried out. And at the time of notification, the notice has been issued to the appellant's hearing, but they have not raised any objection. And their consent, the mutation has been done in my favor. And the property is in my name. I am in occupation of the property. I have constructed a new building also, permanent building. I am residing there. If the injunction is granted, then there will be some problem. I will face some problem. And there are concurrent funding of both the court building. Here I am also one of the daughters of the original recording, because I have looked after my father and they have not.
You are residing in the property?
Yes.
I don't think there is any necessity for an interim injunction at this stage. Let the appeal be heard.
Nature, character, so far as possession part is concerned, there's no denial. So far as nature, character possible, let the property remains the way it is today, my lord. If suppose, my lord, what would happen?
You've lost in two
I am
things,
not,
sir.
I will just not.
So I am afraid I don't think an injunction. Interim order, let it be heard substantially. Prepare your paper books and come.
Yes. No.
Can 1 of 2023. The appellants seek an order of injunction upon the opposite party respondent not to change the nature and character of the property in question. Stop. The appellant filed a partition suit paragraph against the respondent before the trial court, and upon a judgment and decree being passed against them, an appeal was referred before the learned district judge, Andaman and Nicobar Islands. Stop. The appeal was also dismissed. Stop. Paragraph. Learned counsel for the respondent submits that the respondent has been residing in the plot in question by raising a residential house therein. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, we are inclined to hold that there is no scope for granting an interim order at this stage. The appeal be disposed of expeditiously.
The lower court record be called.
I'll do that. I'll do that. Can 1 of 2023 is dismissed. Paragraph. Give the number of the appeal. Yes. Appeal has been admitted. Paragraph. Call for lower court records. The appellants should prepare requisite number of paper books within 4 weeks.
4 weeks, motion.
Within 4 weeks from date. Paragraph. The matter be placed before the next available circuit.
Just only one indulgence. Once the LCR reaches court, my lord, Under the appellate side, the registry has to give a notice to me for inspection of record, based on which I can prepare. Such liberty may kindly be granted.
Prior to this, the appellants are granted liberty to take inspection of the lower court records upon notice served upon them by the registry.
I'm grateful. I'm grateful.
Next,
Same order.
Same identical matter.
same order,
Same.
order is two also.
I am for the appellant, my lord.
Yes,
I tried to serve upon the learned counsel who appeared before the learned court below. He refused
you have to serve the party, sir.
to serve the parties.
Since service upon the respondents
It
is
may-
not,
They
Yes.
fixed on Wednesday, my lord, I will serve in.
can you serve in the
Yes,
meanwhile?
yes, just.
Yeah, right.
Yes.
Let it appear on Friday.
Friday last paper.
Oh, Thursday, I'm sorry, Thursday. Since service upon the respondents is not complete, comma, let the matter stand over till 19.
Obliged. Thank you.
Yes,
My lords, we have served, my lords, but I've got the affidavit. But I have to file affidavit of service.
will you come back next week,
Yes, my lord.
Thursday?
Yes, yes.
Since affidavit of service is not ready, comma, let the matter stand over till 19.
My lord.
My lord, I am appearing for the petition.
My lords, I'm appearing for the respondent's first date.
My lord, here, the very short issue is.
Are you ready?
My lords, the first date, my lords, I've just received, my lords, if my learned friend wants to, because paper books, etc. may have.
No scope of paper book, all the documents.
Documents are-
No, all the documents are there.
Because I do not want to make it part-heard,
My lord,
because this is the first week going to end today.
my lord.
Next week we have just 4 days.
And let it come in the next circuit.
Yes,
My lord, on his prayer, let it be recorded.
yes.
Yes,
Yes.
Learned counsel for the respondents submits that he is yet to receive
just, I have just
instructions.
received the brief, in fact, just
He is
now.
yet to receive instructions in this matter. Paragraph on his prayer, the matter be placed before the next available circuit.
My lord.
Lord, I am for the respondent.
I'm for the petitioner, my lords. This matter is right for hearing, my lords. I can place the case.
You're for the respondent?
Yes.
Petitioner. My lords, this is the case where, my lords, the two members of the Central Administrative Tribunal, the judicial member and the administrative member, they expressed two different opinions. So therefore, it was referred to a third member. The third member has accepted the view of the judicial member without, according to me, assigning any reasons or independently applying his mind. So, my lords, I have challenged the order, passed the majority decision, and also, my lords, I am seeking to rely upon the administrative member's decision. Now, my lords, this is a case, my lords, where the issue is that the petitioner before the CAT, or the original applicant before the CAT, was posted to the Teachers Training Institute. Now, this Teachers Training Institute was earlier operating from the B.Ed college. Then later on, what happened is that the Teachers Training Institute was separated from the B.Ed college and it shifted to a new premises. Now, what happened is that NCT approved teachers, including the original applicant who were teaching in the B.Ed college, were given ad hoc appointment as lecturers in the college. Subsequently, on a recommendation of the UPSC, the UPSC came forward with a recommendation of those of these individuals who, although appointed ad hoc, but through a due process, through a proper process of a selection committee, these people will be given the benefit of service benefits from the date of that's one part, but from the date of their initial appointment. So a set of these teachers, they approached the CAT and they were given the benefit. But in case of this particular individual, the administration's view was that he was not appointed, he was not selected through a proper selection process. So therefore, the UPSC's instruction was not applicable to him. Now, in that light, my lord may first have the administrative members' judgment, because that is what I am also submitting, my lords. So, my lords, it will save the precious time of the Honorable Court also. My lords may see page 48. After that, I'll come to the judicial member. I'll first like to place my case and then I'll place the case of the other side. So, my lords may see page 49. The applicant in this OA has sought the following relief. An order be passed directing the respondent authorities, 1, to award of senior scale to the applicant with effect from 6/7/2002, and 2, to antedate the award of 4 advance increments with effect from 6 July 1998 by counting his past services on ad hoc basis, as has been granted to Dr. Ratan Majumdar and others as contained in instruction of UGR notification 1998 modifying the date of award of senior scale awarded and date of award of 4 advance increments against the applicant in impugned order number such and such, and on benefits of judgment. An order be passed directing the respondent authorities to transmit the record so that perusing the same conscionable justice may be rendered to the applicant, directing the respondent authorities to award senior scale to the applicant with effect from 6/7/2002 and 4 advance increments with effect from 6/7/1998 by counting his past ad hoc service along with all consequential benefits as per UGC notification, set aside impugned order dated 19 September 2017 passed as illegal, cost and incidentals. Now, the applicant has claimed that he is identically circumstanced with the following lecturers, namely Dr. Ratan Majumdar, applicant in OA 123, Shri PM Murali and others, applicant in OA 130, Shadab Hussain and others, applicants in OA 122, and Dr. Satyam Setia and others, applicants in OA 129, all of whom, upon denial of counting of past ad hoc service, preferred applications before this tribunal. In the case of Dr. Ratan Majumdar, on 20th November 2006, this tribunal was pleased to dispose of the OA, directing the respondents to decide the question of applicability of notification on the teaching staff of the Mahavidyalaya and to take further action in regard to determination of pay scale. Pursuant to judgment and order dated 4/9/1998, 12/11/1998 and 27/11/1999, and with the approval of UPSC, the Lieutenant Governor was pleased to order appointment of Dr. Ratan Majumdar and others from the date of approval of UPSC. Similarly, in the case of Shri P. Murali and others, Shri Shadab Hassan and others, and Dr. Satyam Setia and others, this tribunal, with its order dated 14 December 2009, held as under. We have heard learned counsel for both the parties and have gone through the documents placed on record. The learned counsel for the applicants has argued that since similarly placed lecturers selected by the same selection committee and regularized through UPSC by the same order have been granted benefit of ad hoc service for the purpose of grant of senior scale, applicants cannot be discriminated. This is a clear violation of provisions of equality. On perusal of the documents, we tend to agree with this contention because we find that Dr. Ratan Majumdar and others were appointed on ad hoc basis by order dated such and such, and applicant number 1 of the present OA was also appointed by same order. Similarly, other applicants were also appointed with an order dated such and such. They were also regularized through UPSC by the same order. Therefore, the applicants and Ratan Majumdar and others are standing on the same footing. Applicants have averred that at the time of initial appointment on ad hoc, they were qualified as per UGC norms for selection to the post of lecturer and were having MPhil or PhD degree, and therefore they cannot be discriminated. In that view of the matter, we allow this OA and direct the respondents to extend similar benefit of granting senior scale to the present applicants in a manner it has been given to Dr. Ratan Majumdar and others, provided they otherwise qualified as per rules. This applicant has approached this tribunal in OA 59, praying for extension of same benefits, that is, counting of past ad hoc service with effect from 6/7/1998 for the purpose of antedating senior scale, with effect from 6/7/2002 under Career Advancement Scheme for advance increment in terms of UGC notification as granted to the other lecturers. He is aggrieved as his prayer has been turned down. Now, my lords, the admitted facts that emerge from the pleadings are as under. The B.Ed College started functioning in the island since 1981 in the common building of JBT Training Institute. It is affiliated to Pondicherry University and recognized by the NCT. It offers B.Ed training program leading to B.Ed degree to the graduates and postgraduates of the islands. The National Council for Teacher Education is a statutory body established in December 1998 through Act number 73 of 1993 of the Parliament and vested for statutory authority for achieving planned and coordinated development of teacher education system throughout the country, regulation and proper maintenance of norms and standards in teacher education system and for matters connected therewith. It has become mandatory for all the colleges, institutions imparting teacher training to get recognition by NCT by the year 1995. Since the administrative control of the college was initially under Director of Education, teachers posted in Junior Basic Training Institute and qualified to teach in B.Ed classes were engaged to teach in B.Ed. Three of these teachers were later appointed as lecturers on ad hoc basis in 1982. In addition to these lecturers, other qualified teachers posted in the Junior Basic Training Institute who could teach in B.Ed classes were engaged to teach in B.Ed. Generally, while teachers are posted to Teachers Training Institute, the incumbents capable to teach B.Ed teachers are specifically posted so that B.Ed classes can also be managed. These teachers were working as lecturers while drawing the salary of GTTs and PGTs. In order to fulfill the conditions of NCT for the continuance of its recognition, the TTI was separated from B.Ed College and shifted to its new building at Garacharma in the year 1990 at Video Order number such and such. Administrative control of B.Ed College was also placed under the direct control of Secretary Education. Dr. Jana, that is the original applicant in this case, was transferred and posted to Teachers Training Institute, Port Blair, with a Director of Education's order number 2158 dated 19th August 1994 as per PGT Maths to teach mathematics to Junior Basic Training Institute trainees. In addition to this assignment, he was also given B.Ed as given to other teachers. In order to fulfill the conditions of NCTE for the continuance of its recognition, the administrative control of B.Ed College was placed under direct control of Secretary Education with the administration's order dated such and such. While the process of regularization of 4 of the above ad hoc lecturers was considered in pursuance to Honorable Cat's order in OA number such and such and the written submission made by the candidate in OA number such and such with the UPSC, administration in the case of Dr. B.K. Jana, that is the applicant here, even without receiving any request representation from him for regularization of his case, took a decision to forward his case also to the Commission for Regularization as he was similarly circumstanced with the other candidates. Accordingly, a proposal was submitted to UPSC to consider his case along with the above 4 candidates with the administration's letter dated 22nd March 2001. In response to the above proposal, Chairman UPSC Vide his DO letter number such and such dated 11 June 2001 informed the inability of the Commission to consider his case in view of constitutional provisions and government instructions. Dr. Jana made his first representation for the consideration of his case for regularization and against the decision of the Commission as contained in letter above to the Chairman UPSC New Delhi, Honorable Lieutenant Governor and Secretary UPSC dated 2nd July 2001 and requested to consider his case for regularization in the post of lecturer. Thereafter, Dr. Jana filed an application with a OA number such and such in Honorable CAT at Calcutta on 28th August 2001, in which tribunal passed an order directing the respondents to file reply within 6 weeks and then rejoinder by 2 weeks without any interim protection. Aggrieved as such, Dr. Jana appealed before the Honorable High Court against the order of the tribunal dated 28th August 2001, with a WPCT such and such. The Honorable High Court passed an order stating that we do not feel to interfere with the order of refusal of grant of any interim order at this stage. Therefore, writ petition stands dismissed and the petitioner will be OA number such and such filed earlier at Calcutta on 28th August 2001 came up in the circuit at Port Blair on 19/11/2001, and this tribunal was pleased to dispose it of with the direction to the respondents to consider to dispose his representation by issuing a reasoned and speaking order expeditiously and within a period of 4 weeks from the date of service of copy of its order. In pursuance to order dated 19/11/2001, Secretary Education disposed of representation with a reasoned and speaking order with a office order number such and such. Against the said or above order dated such and such, Dr. B.K. Jana filed another case in the High Court with a WPCT number such and such, and the Honorable High Court disposed of the case. In pursuance of the above order, the Commissioner cum Secretary Education once again forwarded the case of Dr. Jana to UPSC for consideration, and decision of the UPSC was communicated to Dr. B.K. Jana with the administration's order dated such and such. Dr. B.K. Jana had filed his 4th case against the above order dated such and such issued by Commissioner cum Secretary. In pursuance to CAT's judgment dated 21st March 2003 in OA number such and such, with the administration's order number such and such, that is date of approval UPSC, Dr. B.K. Jana was appointed on regular basis in the post of lecturer. So therefore, this chain came to an end. The issue of antedating award of senior scale to Dr. B.K. Jana, now this is what we are concerned with. The issue of antedating award of senior scale to Dr. B.K. Jana was considered by the screening committee in pursuance to the Honorable CAT's order dated 15th February 2010 in OA 3 ANN 2010, and in accordance with the instructions contained in UGC notification 1998 point number 8 and clarification received from MHRD with their letter number such and such dated 10th October 2007. The committee found that since the grant of senior scale cannot be extended from the date of regularization, recommended to antedate the senior scale from the date of regularization, i.e. from 9/9/2003. This, the first thing actually it should be from the date of appointment. Since the grant of things is typing error, senior scale cannot be extended before, okay, before, then it's correct. Before the date of regularization, recommended to antedate the senior scale from the date of regularization, i.e. from 9/9/2003 with a order number 2588 dated 14/7/2010, along with all other similarly situated candidates of all the colleges of ANN Islands like JNRM, MGCC. In addition to the above admitted position, respondents refute the claim of the applicant have award as under. So far as the grant of benefit of advance increment is concerned, the matter has been examined and it is found that the benefit has been extended by the ANN administration to the eligible lecturers, assistant professors, associate professors, either on the recommendation of UGC guidelines 1998 or UGC guidelines 2010 as applicable to them. Neither violation of the guidelines nor disparity in granting the benefit of acquiring MPhil or PhD has been done in any case. Dr. B.K. Jana has been granted 4 advance increments with effect from 9/9/2003, that is the date of his regular appointment, for having PhD degree at the time of regular appointment, and Dr. Mrs. Nirupama Roth has been granted 4 advance increments from 19/9/2001 for having PhD at the time of regular appointment. All other cases in the college have been examined and found them in order, and therefore no disparity has been shown to Dr. B.K. Jana for extending the benefit of having PhD at the time of regular appointment. In the case of Ratan Majumdar and others, applicants were called through advertisement and they were selected by duly constituted committee for appointment on ad hoc basis. While it was not in the case of B.K. Jana, Dr. B.K. Jana was a PGT at the time of his transfer and posting in TGCE in 1994. He was a departmental candidate, not a fresh recruit. His candidature was therefore not scrutinized by a selection committee. He was never selected by the ANN administration by duly constituted selection committee. Respondents have reiterated that as per UGC regulations, counting of past service is allowed only if the posts were filled in accordance with prescribed selection procedure as laid down by the government, and past service can be counted provided the incumbent was appointed on the recommendations of duly constituted selection committee, which never happened in the case of Dr. B.K. Jana because he was working as PGT in the college at the time of his ad hoc appointment. Hence, the respondents would claim that the case filed by Dr. B.K. Jana for antedating of senior scale is not tenable and liable to be rejected. We have got the learned counsel and perused the materials on record. We note that respondents have vehemently denied that applicant was ever selected by ANN administration through a duly constituted selection committee. They have emphasized that he was a departmental candidate and was not a fresh recruit. His candidature was not scrutinized by a selection committee, and as per UGC regulations 1998, counting of past services allowed only if the post was filled in accordance with the prescribed selection procedure as laid down by the government. The major point of adjudication in the instant case is whether the applicant was similarly placed to the applicants in OA number such and such. From the pleadings and the records submitted by the parties, the following transpires. 1. The applicant was substantively appointed as a postgraduate teacher. 2. While functioning substantively as PGT and drawing the salary of PGT, the applicant was placed in the diverted capacity in TGCE as a lecturer purely on ad hoc basis. The temporary placement in diverted capacity was to fulfill the conditions of NCTE norms. The applicant was under the control of Director of Education. The arrangement to engage the applicant as an ad hoc lecturer in the Junior Basic Training Institute, while being appointed suitably as a PGT, the Director of Education merely indulged in a work arrangement to fulfill the NCTE norms, and as no substantive recruitment of teachers on a regular basis was contemplated at that point of time, there was no open advertisement to recruit lecturers in TGCE. That in order to fulfill the conditions of NCTE, the Teacher Training Institute thereafter was separated from the B.Ed, and the administration took control of B.Ed College, which was placed thereupon under the direct control of the Secretary, Department of Education, Hon'ble and Nicobar Administration. That in order to fill of the post of lecturers in the colleges, an open advertisement was issued in the year 1994 to appoint lecturers in JNRM, MCG, and TGCE. The lecturers selected through such open advertisement were appointed on the basis of recommendations of a selection committee, and the direct recruits, after having completed successfully in the process, were engaged initially on ad hoc basis by the respondent authorities. The applicants in OA number this, and this were all appointed as ad hoc lecturers consequent to such open advertisement based on recommendations of the selection committee. The advertisement issued for this purpose is recorded at WN2 Collie to the written notes of arguments of the respondents. Post of lecturers in 18 different subjects were advertised with corresponding number of vacancies. Consequent to the recommendation of the selection committee dated 17/5/1995 onwards, the committee recommended appointment of lecturers in different subjects as advertised in public domain. Now, this Roman 9 is very important because when my lord will see the other view, the majority view, that seems to proceed on the basis that no material was before the tribunal to actually assess that Dr. B.K. Jana's appointment was different from these other people. The following materials was brought on record: copies of advertisements inviting applicants for the post of lecturers in various subjects in JNRM and MCGC, dated such and such, lists showing candidates sponsored by Employment Exchange, copies of list of candidates provisionally selected for interview, copy of press note dated 25/3/1995 intimating the dates of venue for interview of selection of suitable candidates, the specimen copy of interview letters, constitution of committee as notified on 12/4/1995, copies of proceedings of the selection committee to select lecturers in various disciplines, copies of appointment letters of lecturers on ad hoc basis selected in JNRM and MCGC have been furnished by the respondents during hearing. The above clearly establishes the following: A, that the administration had advertised posts of lecturers in certain discipline and all eligible candidates were at liberty to apply for the same. The B, that a selection committee was formed to recommend the suitable candidates in various disciplines for the purpose of ad hoc appointment as lecturers in JNRM and MCGC. C, the selection committee met on the scheduled dates and recommended candidates as per discipline, and that thereafter on 29/7/1995, the candidates were engaged on ad hoc basis in the post of lecturers. While the applicants in OA number such and such and such and such were enlisted in the said orders dated 29/7/1995, the applicant who had admittedly not responded to this public advertisement did not stake his candidature against the open advertisement and consequently interviewed by the selection committee for this purpose. Now, this is very important. This is a clear point of distinction. Hence, his name did not find mention in the select list dated 29/7/1995. The applicants in OA number such and such had approached the tribunal stating that as similarly placed lecturers selected by the same selection committee and regularized through UPSC by the same order had been granted benefits of ad hoc services for the purpose of grant of senior scale, the applicants cannot be discriminated. The OA was allowed upon the findings of the tribunal that the applicants in the aforementioned OAs were appointed on ad hoc basis by the same order dated 29/7/95 and regularized with effect from 10/5/1999 through UPSC by the same order dated 26/8/1999, and hence, according to the tribunal, the applicants stood on the same footing, and it was directed that the applicants be granted similar scale and similar benefits as similarly placed lecturers. Now, this is very important, my lords, in my humble submission. Upon a reference of the administration, MHRDC had clarified as follows. So, this is the basis of all these arguments. My lords may see this is addressed to Shri SP Dash, Assistant Secretary Education, UT Administration. And this is issued by the Government of India, Ministry of Human Resources, Department of School Education and Literacy. Sir, I am directed to refer to your letter number such and such dated 11th April 2007 on the subject and to say that the matter has been examined in consultation with the UGC. The UGC is of the view that period of ad hoc services of lecturers who were appointed on ad hoc basis by adopting the process of selection by the administration and on the recommendation of a selection committee constituted by the Chief Secretary may be counted for placement of lecturer in senior scale. So only if the candidate was appointed through the process, proper process of selection and on the recommendation of a selection committee and not merely for the purpose of convenience. In those situations, only this benefit of scale would be given from the date of appointment. Not, and otherwise it has to be from the date of regularization or regular appointment. So basically, those who were appointed through a regular selection process, although they were given ad hoc appointment, upon their regularization, the service benefits like scale, promotion, also things like pension would be affected by that, would be given from the date of their initial appointment on ad hoc basis. But in the case of this applicant, where admittedly, according to us, according to the learned administrative member, he was not appointed through a proper selection process, and only for the sake of convenience, his services were utilized during the ad hoc period. His benefits, his service benefits will be from the date of his regular appointment. That is the issue. It is noted herein that this particular clarification has not been challenged by the applicant in the instant way. If this clarification has been successfully challenged elsewhere, the results of such challenge has not been brought before us while adjudicating the instant OA. The applicant in the instant OA, and now these are the findings of the learned administrative member, and the applicants in OA number such and such are not similarly circumstanced on account of the following reasons. One, the applicant was primarily and substantively a postgraduate teacher maths in Teacher Training Institute under the control of Director of Education. In order to be able to meet the NCT norms purely as an ad hoc measure, the applicant was engaged in diverted capacity to function as lecturer in the TTE and for some classes in the B.Ed college for intermittent period not exceeding 6 months until the B.Ed college along with JNRM and MGC came under the control of Secretary Education. None of the engagement orders or extension orders is all appreciation of evidence on record. It's of the applicant, there is any record to substantiate that the applicant was ever engaged in B.Ed college, JNRM or MGC as a regular lecturer. The applicant was always associated with Teachers Training Institute, namely Tagore Government College of Education, Port Blair.
These are admitted facts.
Yeah, no, this is not admitted. This is the
But this is
admitted.
not in dispute.
No, this is in dispute because the administrative member and my submission is that the applicant has not placed anything on record to show that he was appointed through regular selection process. When my lord will now come to the judicial member has formed the view that there is no evidence to show that he was not appointed through regular selection process. So this is to show that in at least so far as the administrative member is concerned, she has appreciated the evidence on record and then held that he is not entitled to parity. So my lord, very well, I'll not read the rest of the order because my lord says, I think I've placed that. Now my lords may see the decision of the honorable, the learned judicial member that begins at page 35.
Yes.
So this first page, of course, is the prayer and the background. This is the same as what. Now, my lords may see the way in which the learned judicial member has appreciated the facts. Para 3. The first Roman 1 and Roman 2, these are all common. I mean, there is no difference. But my lord may then see Roman 8 at page 38. Roman 8, the learned judicial member notices, while the process of regularization of 4 of the above ad hoc lecturers was considered in pursuance to CAT's order and the written submission made by the candidate. This was also mentioned in the earlier, so I don't think I have to read this. This is the same as what was recorded earlier. Even on the next page, page 39, this is exactly the same. Then para 4.
These are admitted facts. Both
of us said the same thing.
Yes.
So likewise, para page 40 also, my lord will see these facts are not disputed. Now, para 5 onwards, we have heard the learned counsels and perused the materials on record. In view of the position SUVRA, since the dispute arose about the nature of appointment of the applicant, we sought for certain clarifications where respondents were directed to disclose the documents on the basis of which the post of lecturer in government training college was filled up with the order to discern whether it was advertised and then filled up and whether the appointed lecturers have responded to any notification in order to be appointed as such. Now, this is a finding of fact which is completely different. So, my lords, that is the difficulty. The learned judicial member says, despite opportunity, no clarification to this effect have been furnished. We note that the respondents have vehemently denied their applicant was ever selected by AN and administration through duly constituted selection committee. They have emphasized that he was a departmental candidate and not a fresh recruit. His candidature was not scrutinized by selection committee. As per UGC recommended regulations, counting of past services allowed only if post was filled in accordance with prescribed selection procedure. In order to decipher whether the applicant would be constituted as would be considered as duly selected, we noticed 1 on 25/11/1994, the departmental qualified candidates having requested sponsoring of their names for appointment as lecturers. 5 such candidates were sponsored by employment officer. On 13/12/1994, advertisement was floated notifying the applicants for eligible for filling out several vacancies for post of lecturer in various disciplines in JNNRM and Mahatma Gandhi Government College, Mayabandar on ad hoc basis. Education qualifications and other requirements, this is mentioned. Then by an order dated, my lord may see on the next page, by an order dated 29 July, 14 lecturers were appointed. Now, my lords may see, there is no, this applicant is BK Jana is not there in this serial number 1 to 14. Such ad hoc appointment continued until they were regularly appointed. With an order dated 6 July 1998, applicant BK Jana was granted ad hoc appointment as lecturer against one of the 3 vacant Group A gazetted post of lecturer for a period of 6 months, and such appointment continued. The order is extracted hereunder for clarity. An exercise of powers conferred by Central Civil Services such and such Andaman Nicobar Administration has been pleased to appoint following postgraduate teachers against 3 vacant Group A posts purely on ad hoc basis with effect from the date of they assume the charge of their respective posts for a period of 6 months till posts are filled up. The ad hoc appointment is subject to the following. They are being found eligible, suitable for post of pondicherry, governed by relevant rules, no claim for regular appointment to the post. Alike the 14 incumbents dealt with SUVRA, such ad hoc arrangement is continued until he was regularized. So therefore, it is clear from here that this does not show that he was appointed through the same process. Now, by an order dated 7th October 2003, the applicant BK Jana was appointed on regular basis with effect from the date of approval of UPSC to the post of lecturer. On 10th October 2007, in pursuance to the tribunal's order dated, Ministry of Human Resource Development intimated Assistant Secretary UT as under the same letter which I read out earlier. A screening committee met on to consider the placement awarding of senior scale to Shri BK Jana lecturer in accordance with the direction of tribunal and observed as under. Now, my lords will see the case of BK Jana was considered and all these conclusions were arrived at. And therefore, my lords will see, in fact, my lords, may I just read this? The screening committee examined from page 44, case of BK Jana lecturer for antedating of senior scale under the career advancement scheme. According to UGC guidelines, the lecturer will be eligible for placement in senior scale through procedure if he has completed 6 years, participated in 1 orientation course, 1 refresher course, consistently satisfactory performance, previous service without break. Committee examined the case of BK Jana in accordance with UGC guideline, clause 8.8, previous service without is university college should be counted for placement, provided the post was in an equivalent grade scale, qualifications for posts were not lower, candidates who apply for direct recruitment should apply through proper channels. The concerned lecturer possessed minimum qualification, post was filled in accordance with the prescribed selection procedure. Appointment was on ad hoc basis or in leave vacancy of less than 1 year duration was not. Ad hoc service of more than 1 year would be considered provided ad hoc was more than 1 year duration. Incumbent was appointment on recommendation of duly constituted selection committee. Incumbent was selected to the permanent post in continuation to the ad hoc service without any break. The case of BK Jana and 2 others on the post of lecturer on ad hoc basis were examined in the past. In April 1990, regional committee NCT confirmed that among other lecturers, BK Jana has requisite qualification as per NCT norms. The services of BK Jana was regularized by UPSC with effect from 9/9/2003 in pursuance to CAT order. The Honorable CAT Viday's judgment has ordered this administration to consider the case of BK Jana in accordance with case of such and such. In these cases, a selection committee under Chief Secretary was constituted. Applicants were called to advertisement and these lecturers were selected by this committee for appointment on ad hoc basis. However, this was not the case of Dr. BK Jana. Dr. Jana was a PGT at the time of appointment. He was departmental candidate and not a fresh recruit. His eligibility was cleared by NCT. His candidature was therefore subject to scrutiny process and not through selection committee. DPC was of the view that scrutiny selection process for appointment of Dr. BK Jana in TGC is in line with spirit of 1998 and his case could be considered accordingly. The DPC examined the ACR's integrity and vigilance clearance of BK Jana. Dr. BK Jana was regularized in 9/9/2003. Subsequently, he was given senior scale with effect from 9/9/2007 in accordance with UGC instructions as contained in para 3. In case the ad hoc service with effect from 6/7/1998 is taken to consideration, then senior scale should be given from 6/7/2002. But BK Jana was ad hoc on 6/7/2002. Therefore, he can only be given senior scale with effect from regular appointment, i.e. 9/9/2003. Keeping in view the aforesaid guidelines and considering that the period of ad hoc was without break, DPC recommends to award him senior scale with effect from my lords will see that it is given from the date of his regular appointment 9/9/2003. Above perusal of the order demonstrates that the only reason why his regular appointment and senior scale were not antedated was due to the fact that applicant was a departmental candidate. In regard to 4 lecturers appointed in 1995, Vidya an order dated such and such, whereas applicant who was identically appointed but as a direct recruitment was bestowed with effect from 2003. In 14/7/2010, in view of such recommendations, senior scale of pay of applicant was antedated with effect from 9/9/2003 with a stipulation. Now, my lords will see para 8, the finding. We infer from the records as enumerated supra that the only stumbling block in regard to the applicant entitlement to senior scale from the date of initial ad hoc appointment being the manner in which he was appointed, i.e. without being routed through a selection committee. We feel the production of records was an absolute necessity in order to determine whether the applicant was discriminated vis-a-vis the other lecturers. Now, I pause for a moment. This burden is always on the applicant if he is alleging discrimination. In absence of such records, we can only presume that the applicant was selected on ad hoc basis alike others. Having noted that as a departmental candidate, his case was not required to be routed through employment exchange or considered by a duly constituted selection committee, and that his candidature was only subject to a scrutiny as a departmental candidate, not a selection as a direct recruitment, failed to decipher any notable difference in ad hoc appointment of applicant vis-a-vis other lecturers. Having noted the applicant was duly qualified at the time of his initial ad hoc appointment and fulfilled UGC norms, and being a departmental candidate who was not selected afresh but regularized after due scrutiny, therefore was not required to be recruited by selection committee. And having noted that he discharged duties of lecturer, we can only direct the authorities to extend senior scale with effect from date of his appointment as lecturer, albeit on ad hoc basis, unlike the other lecturers. So the judicial member has arrived at this conclusion on 2 bases. First, he says that the learned judicial member says that there is no record that is placed to show that he is discriminated, but that burden is on him, it is not on the administration. And secondly, the same records have been, this is a distinct difference of view on a question of fact, which is why it was referred to a third person, because the same material has been appreciated differently by 2 learned members. And then the learned judicial members, in a sense, overrules the government's instruction, where the government has said that selection committee is mandatory. She says that selection committee cannot be a requirement in case of this gentleman because this gentleman was a departmental candidate. So that is a view which the learned judicial member has formed. Then it is referred to a third member. Now this assumes importance. My lords may have page 60. Now kindly see this, my lords, page 60. The view or opinion of Mr. Swarup Kumar Mishra. Now, para 1 is, of course, the facts. Para 2 is also the facts. Para 4, again, the opinion of the administrative member is set out. Then para 5 at page 63. In view of, kindly see, my lords, in view of the divergent opinion of the division bench, Honorable Chairman, in exercise of power conferred under Section 26 of Administrative Tribunals Act, referred the matter to third member to resolve the issue. None appeared for the respondent. So it's an ex parte order. This being a year-old matter of 2017, it was felt not to grant any adjournment. Hence, learned counsel for the applicant, produced the records, including all record of the honorable members. Before expressing any opinion on the issue, it is worthwhile to consider the ratio decidendi of a case. Sir George Jessel in Osborne versus Rowlett remarked that the only thing in a judge's decision binding as an authority upon a subsequent judge is the principle upon which the case was decided. The basic question of law that has to be decided, therefore, is whether the ratio in OA number such and such and how far that would be applicable in the case of the present applicant. The doctrine of precedent that is being bound by a previous decision is limited to the decision itself and as to what is necessary involved. Further, it is strike law that Article 16 of the Constitution of India, it's unclear in my copy. Is it unclear in your lordship's?
Yes, it's not very legible.
My lord's grant of similar benefits have been, do you have a better copy of the? Your copy is still slightly better. Can I just? Now, even every discriminatory action has arbitrariness within it. Therefore, such action would not only be hit by Article 16, but also by Article 14. The state cannot discriminate between citizens who are placed equally. Fundamental right against discrimination is available not only in matters of employment, but is also available in matters relating to grant of similar benefits. Further, it is profitable to note that once a controversy has been settled, final judgment is required to implement it to all employees. It was also held by Honorable Apex Court. The relief granted by court is to be given to other similarly situated employees without forcing them to go into court for similar benefits. Same view was expressed by Apex Court in such and such. Then, my lords, we see the Constitution Bench of Apex Court in the case of R.C. Sharma, while tribunal in OA number such and with greater respect may be recorded, the honorable member came to conclusion based on the points which are not available to be canvassed before the implementation of orders in OA number such and such. Settling the issue at rest and conclusion that the aforesaid cases are different is not supported by fact and law. In view of the discussions made I hereby agree with the findings and view taken by honorable member judicial, and the OA stands disposed of by reiterating the findings and view taken by honorable member judicial. Member judicial and the OA stands reiterating authorities to extend the senior scale to the applicant with effect from the date of his appointment as lecturer, albeit on ad hoc basis. Now, here, my lords, according to me, my lords, there is when there is a difference of opinion between two members on a question of fact. It is the third member is to act has to independently apply his mind and say that why the decision of the administrative member is right or why the decision of the judicial member is wrong or correct, either way. In this case, no view that the third member has not at all looked into the facts of the case on a general proposition of law that benefit should be given to similarly placed.
You were served notice before this hearing was taken up?
My lords, I will assume that, my lords, that I'm not saying that it was ex parte in the sense that I was not given notice. That is not my case. I am only submitting that even assuming it was ex parte, the third member was required to apply his mind, and then that is why it has been referred to a third person as to why the view of one member is wrong or right. He has not at all applied his mind to the facts. He has simply stated as a general proposition of law that benefits should be given to, but the whole question is whether they are similarly placed. That has been appreciated in a certain manner by the judicial member and likewise appreciated a different way by the administrative. So the third member was required to apply his mind and say that why they are similarly placed or not similarly placed. He cannot simply agree. This is not, my lords may appreciate, this is not a case of a judgment which is given by, say, three members of a bench, where, my lords, the third member can simply agree or disagree. This is a case where, my lords, it is referred to a third member.
A fresh consideration.
A fresh consideration is required. So my humble submission is, my lords, the third member has not applied his mind, and, my lords, this matter should be remanded and sent back to the tribunal to consider. Now the members are not different, so it can be considered by the present bench. So, my lords, in my humble submission, because I am not inviting your lordships to, then otherwise your lordships will have to take a view as to what is the correct opinion.
Yes.
Let kindly come to page 87.
Yes.
This is the initial appointment, my lord. My lord, kindly see, my lord.
Learned counsel is not on merits at all.
My lord,
He has not submitted on merits.
my lord,
You've heard the submission.
my lord, I retired 13 years before. Now I am 75. For the last 15 years, I am running pillar to post. How many years, my lord, I will run further?
But you agree that there is no independent
No,
consideration?
independent consideration is there.
What is the independent
My lord.
consideration? Please come to the order.
My lord, yes, page 63.
Yes, page 63.
Page 63, tribunal in OA number so and so, with great respect, it may be recorded that the honorable member came to the conclusion based on the points which are not available to be canvassed after implementation of the orders of OA, so and so. Hello, kindly see prayer made in the original application first.
Where is the independent application of mind to decide which of the members held correct?
Well, it is there, my lord, in the order passed by the third member.
Please
It
show
is
me the order
Page
passed by the third member.
63.
Yes, page 63. Where is the independent consideration?
My lord,
This is only the ratio has been laid down.
why it was ratio was laid down, my lord? I
Yes.
approached the tribunal for extension of benefit of the judgment passed by the tribunal. Kindly come to my prayer first, my lord. Kindly come to my prayer first, my lord.
At page
One second.
Can use my. There is no imagination.
Pagination, wrong pagination is there. Kindly come to page 84. In my application, it is page 80.
Yes,
Page 84,
85 होगा, but that is
nearest to 84,
that will be 85.
is 85.
yes. Release sort.
Release sort. A may be seen, an order be passed directing the response authorities to award senior scale to the applicant with effect from 6/7/2022 and to anticipate the award of 4 advance increment with effect from 6/7/1998 by counting his past service on ad hoc basis has been granted to Ratan Majumdar and others as contained in instruction of UGC notification 1998 modifying the award of senior scale awarded and date of award of 4 advance increment against the applicant in the interim order number so and so and or benefits of the judgment passed in OA number so and so. I mainly prayed, my lord, benefit of the judgment passed by the honorable tribunal. Now, my lord, kindly come to the tribunal's judgment passed by the tribunal, my lord. It is appearing at page 140.
One 40,
140.
yes.
My lord, kindly see 139 maybe seen first. There are around 10 applicants. 10 applicants.
Yes,
Now, my lord, they approached the tribunal. Everybody was on ad hoc service. They approached the tribunal. Tribunal passed the order, extend the benefit. That benefit was extended. I prayed before the tribunal. Benefit of this judgment. That was extended to me. What is the wrong in it, my lord? I am asking myself. This order they did not challenge. They accepted this. They implemented the order.
this order has nothing to do with, so there was no question of challenging this or this judgment.
No, if they accepted this judgment, so it is applicable to me also.
That is the point. They have accepted this judgment because you are nowhere in this judgment. You
No.
have claimed parity in terms of this judgment.
Yes,
Right.
that was awarded to me.
So both the members, they differed in their views.
My lord,
The third member ought to have taken this independently instead of only support. Please come to page 63. The proposition has been laid down and then it is said that yes, this judgment will be applicable. But where is the consideration?
my lord, my submission before the tribunal is that I am playing for extension of benefit of the judgment.
There should
This
be
benefit
some
was extended.
benefit will be extended to you provided you are entitled to the same.
I am entitled, my lord. I am showing.
That
from
is
the
your
record.
case. Where is the observation in page 63 that you are entitled to this?
My lord,
Where is the consideration by
my
the
lord,
third judge?
consideration is that my prayer before the tribunal is extension of benefit of the
No
judgment.
dispute, no dispute. But that prayer has to be considered on merits
Yes, it was considered by the member, my lord.
by the third judge. Please show me where is the consideration on
Yeah,
merits.
The entire, then we have to go through the entire order.
The third judge.
Yes,
Yes, please show me the relevant part where it has been considered on merits. Only the ratio has been laid down.
sir, this there, page 62 medicine, I cannot read this paper.
Page 62, yes.
62,
This is the administrative member's order which has been set out.
yes. My lord, nothing wrong in the order, my lord, kindly appreciate, my appointment may be seen first, my lord. Page 78,
Sir, one simple question.
my lord.
Where is the independent consideration by the third judge?
It is there, my lord, in the order, my
Simply,
prayer-
it is the saying it is there will not help, sir. Please show me where it is.
My lord,
I am with the order. I have, yes.
my lord, kindly don't take it over.
No, yes,
I might prayer before the grant, I don't believe that extension of benefit.
yes.
That benefit was extended.
Without any reasons.
My lord, benefits, the extension of benefit, no reason is required.
For extension of benefit, no reason is required. The parity did not be proved
First judicial member is order, it is there, my lord. First judicial member.
because there was a disparity. Yes, because there was a disagreement. It was referred to a third member. So the third bench cannot blindly support any one of the members.
Was not blindly supported. my
So
lord.
that is exactly what I want you to show, sir.
The third judge, my lord, relied upon the judgment passed by the tribunal.
But then he should have discussed how it is applicable in your case. Has that been done?
But that was done.
Please show me, please show me where it is done, sir.
In terms of the.
Please show me where it is done. What does page 62 say?
Can I read, my lord? This is, no, I can't listen. I cannot read this paper. That is not, I think it is.
Page 62 is the administrative members, it's set out.
Yeah, the difference is only 5 years, not much.
Has that been decided by the third judge?
Yeah.
Has that been decided by the third judge?
My respectful submission is that third judge opined in the page number 62.
Page number 62 is the,
62 and 63. Extension of-
I do not find any opinion of the third judge.
Only received is.
Paragraph 7 starts with, before expressing any opinion on the issue, it is worthwhile to consider the ratio. The ratio has been set out. Then where is the opinion after that?
Page 62 onwards, my lord.
Yes, only I find only the principles have been referred. How is it applicable to your case? There is that discussion in the order, in the judgment.
Okay, that the order passed by the tribunal squarely applicable to the present case.
So, suppose we pass an order today that is the order passed by the third judge is bad in law. Sufficient? No reasoning necessary?
I do not get any benefit from it.
So no reasoning necessary for it? Whether you're getting benefit is consequential.
Kindly appreciate one.
Let it be remanded to the third judge for fresh consideration. I do not find any consideration in the order, in the judgment.
Another 5 years, my lord. By that day, I will go.
Getting pension.
I'm getting pension and benefit, that is altogether different.
Just
The point raised by the. other
Your
side,
issue is the senior scale.
Senior state
Yes.
is affected from the date of.
So it has to be adjudicated, sir.
Was adjudicated, my lord, for 15 years I'm running.
That is what I'm repeatedly asking you. Please show me the adjudication. You are not able to show me.
It's there in your, I cannot travel.
It's there in the order. I mean, I don't know whether it's hidden in the order. The order as it is reflected, I do not find.
Like that, page 62 and 63.
Please
No.
help him with the,
Not only that, my lord,
in our copy it is page 64.
Nothing is.
Point that above period can be counted or not. This is the only point. This is the only point.
Where is that decided in this, considered in this judgment? The third judge?
Page 62 and 63, my lord.
I do not find it, I'm sorry.
Because, my lord, the judgment read by me is appearing at page.
And my
140.
brother will agree with me that
Yes.
it's not.
Nothing.
140, page 140.
Independent opinion is not.
There is no independent opinion.
There is no independent opinion.
Point is
Only
very
the
short.
ratio has been laid down.
Point is
I
very short.
understand the point is very short, but it has to be decided. However short a point is. Yes.
Dominant order connected.
So 5 years, by that,
Let it be completed within one month from the date of communication of the order. Yes, 1 month. Heard learned counsels for the parties. The respondent claims to be similarly circumstanced with other lecturers, namely Dr. Ratan Majumdar and several others, all of whom, upon denial of counting of past ad hoc service, preferred applications before the tribunal. Stop. The tribunal
but may I say subject to
Yes.
acceptance, madam? Madam asked me whether it was opined in the order.
independent
I-
opinion.
Independent opinion.
Yes. yes.
Madam, the first order passed by the judicial member, merged with the order passed by the judicial member, third member.
How did it merge, sir? That is the question.
Majority opinion, madam. Majority opinion will
is
stand
not
always.
voting.
This is not a majority opinion
Yes.
case, sir.
Yes, ma'am.
It is only when three members sit together that the question of majority opinion comes. If two support the same view and that is majority opinion.
No, my lord, kindly.
Here it was referred to a third member for independent consideration, not to support any of the views.
No, my lord, kindly play. I will place only one order, my lord, the cat's order.
Yes.
My lord. Yes. Page 64.
The same page, yes.
Page 64, my lord.
Yes.
This single page.
Where is that? Page 64 is part of the third judge's order.
My page will be something else. Cat's order.
Where is that?
Annexure P1. Yes, this is there. This is annexure P1.
Annexure P1.
Yes, annexure P1. 1 second. So this is page 34. Learned counsel for the applicant is present. Yes, this is the first. OS stands disposed of in
Yes.
accordance with the measure.
After passing the order by the third member, this matter was placed before the division bench. Division bench opined that OS stands disposed of in accordance with the majority view. What is the majority view? In my favor. The first judge and.
How was the majority view taken?
My lord,
How was the majority view taken? You cannot just say, I agree. Isn't it? There should be a separate view.
my lord,
It should support either of the members. Where is that view, sir?
my lord, views there, my lord, first judge view, we have to see first one and the third one. Second one is against me. The first judge passed the order. Passed the order in my favor. The administrative member against me. The third member in my favor. Then we have to consider the first one and the third one.
This is not a voting. This is not a voting. Suppose another person comes and says, I agree with that view. So is that sufficient? No.
My lord, kindly
has to
see,
take
OS
an independent
stands disposed
decision.
of according with the majority view.
In fact, that is a mistake because if my lord
See,
sees
it
the
can't be said that
sees the order, if my lord sees the order of the third member, paragraph 5 at page 63,
It can't be
the
said that it is
third
disposed.
learned member specifically says at para 5, page 63, in view of the divergent opinion of the division bench, so
Yes.
bench is division bench. The honorable chairman in exercise of power conferred under section 26 referred the matter to the third member to resolve the issue.
Yes.
So it is like a special bench which is constituted. So the special bench has to decide. Special bench can't just say that I agree.
My lord, that independent decision is to be seen with the first order. Passed with the
Can't
decision
be
maker.
There should be first an independent decision. If the decision goes with the first order, it's a majority. If it goes with the second order, it is again a majority. So, but primarily it should be an independent decision. Where is that independent decision? That is my basic question. I've been asking this for quite some time actually.
Lordship is asking me. at least
Where is
five-
the independent
5
decision?
times you lordship asked me this.
Where is the independent?
My lord, independent decision, my respective submission is that we have to see the first judicial members order. That was not set aside. They have not preferred any appeal against that order.
Not necessary. It's not a single order.
No, my lord,
It's a
yes,
combined decision by both of them.
they have not
They are
changed that order.
I will-
my lord.
Not necessary. Not necessary because the deciding factor is the third judge.
My lord, deciding factor is the third judge. Lordship is
Yes.
absolutely right.
Yes.
But third judge.
And they have
judgment is to
challenged
be-
the third judge's
third
order.
judge judgment is to be seen with the first judge, my lord. Because first judge passed in my favor. And in this order.
And the
I-
third judge has only said, I agree. Is that an order?
No, it is not there, my
So
lord.
please show me the
I
explanation.
agree it's not there. He passed a laborious order.
Where is that laborious order, sir?
Well-
Quote unquote laborious, please show me.
It is there, my lord, in the page 62
Sir,
and
only
63.
submitting that it is there will not matter. Please read out page 62, 63 if you are really keen on this. I do not find one single line of reasoning in the order. Only the ratio of the judgment is laid down and he has said, yes, it is allowed. Where is the reasoning? Please show me one line where the judge has reasoned independently.
Kindly give me 1 day's time, I will come back tomorrow. I'll come back tomorrow. Monday.
Very good, not today.
Let it come on Wednesday. ma'am.
Third learned counsels for the parties. Paragraph on prayer of the respondent. Private respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
My lord.
Obliged.
I am appearing for the appellant.
Passed by the Hon'ble by you in the last. So I want.
I have received,
Modification should be done by the same judge.
I have, I have received the copy of the application today, so I need time to file opposition. Opposition.
Let it be placed before the same judge.
My lord, may,
Yes.
my lord, may direction also direct for filing opposition.
The judge will do it.
My
I'll
submission,
only
my prayer
place
may
it-
be,
I'll only place it before the judge, nothing else.
my lord,
I do not have the determination to even direct you to file an opposition.
my lord,
It has to go before the judge.
my lord.
Since the applicant seeks modification / clarification of an order passed on 26th September 2023. In the previous circuit bench.
Yes,
In the previous circuit bench, comma, the matter be placed before the appropriate bench.
no, my lord,
Place it immediately. It will be placed immediately.
no order. Then, my lord, I may,
Place
my
before the
prayer for
appropriate bench at once.
opposition may be,
The appropriate bench will direct,
My
not
lord.
me. I do not have the authority to direct.
my lord,
Next,
oblige, my lord.
हमारे पास है नहीं एक्चुअली, ठीक है आप शेयर कर लीजिए। फाइल कहाँ है?
affidavits complete?
Paper book is filed.
But the paper book was supplied to the earlier council.
Oh.
Please, they manage it, so okay, otherwise the motion can be fixed on Monday for hearing, I just give up.
आपका भी आई यू शेयर योर
Yes, sir.
There's an application pending. Can 1 of 2022. And affidavits were called for with regard to the application also.
because certain
Application for
additional
additional
documents,
evidence.
that pleadings are complete in that, if I recall
Yes, yes.
correctly. Affidavits in opposition and reply has been filed unless it's.
Opposition reply, both were filed and I think it was
You're objecting to that?
Yes, my lords, but it can be heard finally, so I'm not,
not objecting to it.
no, I am objecting certainly, but point is that
It's their own document.
it's our document and it has been placed, so it can be decided together with the appeal, my lords.
The existence of those documents have not been disputed by them in the opposition.
But
They have not disputed it.
But technically, my lords, my submission would be that this document was not before the learned single judge, so it should go back, my lords. The learned single judge should hear it in light of this.
And in that case, the order may be set aside, the matter may be remanded back to the learned single judge. And it can be heard. The only point, your lordship,
Set
is that
aside,
Of course, otherwise what is the meaning of hearing of the matter by the arresting authority? There won't be any meaning. Page number 33 of my paper book, your lordship may kindly.
Yes,
Now,
this is the letter.
This is the letter, your lordship, which I have relied upon, stating that on the basis of this letter, benefits should be given to the heavy vehicle driver working in the Port Blair Municipal Council also. This is a letter issued by the government of India. Now, in their affidavit in opposition, they have not disputed the existence of this document. They have also not disputed the fact that PBMC is not covered with them. Now, your lordship, even then, the learned single judge has rejected my case and said that I can make appropriate application, but that is not going to help me out. Then before this division bench, I procured some more documents to show that this particular letter has got meaning in the Port Blair Municipal Council also. Those documents I have enclosed along with my application. Just a minute, I'll just share it.
They were not considered by the single, you didn't place them before the single judge. The other
Yes,
documents
yes,
also.
not-
Those were not placed, your lordship. By way of order 41 rule 27, I filed the application.
And these are all old documents, so my lords, then that issue will arise, that whether by exercise of due diligence.
Within, yes, within knowledge.
It was the order sheets of the authorities. It was really within, not within us. Subsequently, only we came to know about all these things.
Have you explained that
Yes, your lordship.
in your application?
Yes, your lordship.
You have annexed only one document with your application.
Yes.
It's an order number 478.
Yes, I have
Of
only one
2006.
document. Yes, thereby it would be clear that the benefit has been given to 3 incumbents of the same department.
The document at page 33 has not been annexed to the application.
No, it wasn't.
I do not find it.
33, it was a part of the original writ petition.
You want the court to place that document before the single bench, isn't it?
No, page
This
number
this
33
document,
of the
page
paper book
33 was
was
placed
already there.
before the single bench.
Yes, this was already there. I filed a separate application before this honorable court. There one document I had annexed. And I
Yes,
can
that is
say-
scan 1 of 2022, isn't it? You have annexed an order
Yes.
dated 6th February 2006.
Yes,
You want the single bench to consider this document.
this document plus, your lordship, what happened? While filing the affidavit in opposition, they have annexed some more document, which in fact is in our favor. I can show it. They have annexed the resolution of the Port Blair Municipal Council, where it has been decided that this issue is required to be considered and matter is to be looked into by the authorities. That document they have annexed along with the opposition.
Because these were not before the single judge, my lords, it can technically.
So let it go before the single.
My lords may
judge.
only say that my lords have not expressed a view on the merits. Because
Yes,
it's
yes,
in view of these
Yes.
documents.
Those the order has to be.
And the order has to be set aside because a fresh order needs
Yes,
to be
yes,
passed.
anyway, it will be fresh.
Where is the order?
Order,
The order in.
But my lords may say that.
I will,
Lalit
yes,
Singh
let
is
us
free
look into
to-
that. We will
Yes,
do
yes.
that. In fact, we are not going into merits. Let
Yes.
the court reconsider.
Page number 70, election. Of the paper. That is the order.
Yes, please. The MA along with the application. Learned counsel for the appellants seeks to produce a document being order number 478 dated 6th February 2006, issued by the Secretary Municipal Council for proper adjudication of their claim. Learned counsel further submits that certain documents have been produced by the respondents along with their affidavit in opposition before this court, which have also not been placed before the learned single judge for consideration. Stop. It is in fact submitted on behalf of both the parties that all these documents be taken into consideration by the learned single judge.
My lords may not record my concession. My lords may pass on. There's no difficulty.
Then delete this slide.
Because we have succeeded before the learned single judge.
Right.
It wouldn't be proper for me.
Learned counsel for the petitioners, the appellant submits that all these documents may be taken into consideration by the learned single judge in revisiting the issue. Paragraph. Learned counsel, the same paragraph, learned counsel further submits that the documents were not within the knowledge or control of the appellants when the matter was considered by the learned single bench. Paragraph. In view of the above, comma, we are inclined to hold that since certain documents have been produced before this court, which the learned single judge had no opportunity to consider, comma, the matter be remanded back to the single judge for reconsideration upon perusal of the said documents, in addition to the material already on record. Paragraph. In view of the above, the order impugned dated
November 22.
November 22, 2021 is set aside. Paragraph. The matter be remanded back to the learned single judge for fresh consideration upon taking in for fresh adjudication upon consideration of the documents to be placed by the, you will place all the documents?
Yes.
By the appellants before the learned court. In addition to the material already available before the court. Paragraph. MA such and such is accordingly disposed of. Those one line, it is made clear that this court has not gone into the merits of the case, and the learned single judge shall decide the case on merits upon considering all available material placed before it. Disposed of?
No, sir.
MA3 along with MA4. Two matters, 8 and 9.
Yes, they are together,
Obliged.
be covered by the same order. Can dispose of.
And for the petitioner.
Private respondent.
Yes,
I'm appearing for the state.
Before I take your lordship to the impugned order, which was passed on 13th of February 2023 by the learned tribunal, I would like to place the facts before your lordship, which is very essential. Only thereafter you will be able to appreciate the judgment of the tribunal. Pursuant to an advertisement.
Yes. Prior to that, my lord, I want to raise a preliminary objection in this case.
mention it.
My lord, this hit by limitation, my lord.
Yes,
Hit by limitation. even though the tribunal dismissed the original application, limitation point is there. Before, by crossing the limitation, my layman friend can argue. I may be permitted to submit on the limitation point only.
I'll answer his questions. Moment, he
Let
makes
him
some.
let him make his submission.
My lord. My lord, kindly come to page 24, my lord.
Yes,
Sorry, my lord, page 27.
yes,
27, my lord, is the order dated 25/11/1998. My lord, lordship will find the date and the middle.
yes,
Now, my lord, kindly see, the petitioner is the private respondent, N. Balakrishnan.
yes.
Serial number 6, the applicant hearing, the petitioner hearing.
Serial number 6.
Yes. R. Venkatramurthy.
Yes, yes,
Now, my lord, kindly see this order, when this order was passed. 25/11/98.
yes,
What is the order? Lordship, kindly come to page 29. Only I will take your lordship to the operative portion only.
yes,
5 lines from bottom. So, in view of the aforesaid circumstances,
yes,
the applicant should be given all benefits by creating a supernumerary post, and he should be placed over the respondent number 6 to 9.
yes,
Who is the 6 to 9? 6 is the present petitioner. It should be done within 3 months from the date of communication of the order.
yes,
My lord, this order reached finality. It was never challenged. The present OA filed before the tribunal is after 15 years, 4 months and 2 days. The limitation prescribed under the AT Act is 1 year.
this order is not challenged in the present application.
No. This order was not challenged.
So there was a further application before the tribunal
Yes,
by the same person.
yes.
Where is that application? Or rather the order?
Impugn order, my lord, page 69, I believe.
132. 132.
132. Sorry, it is 132.
The 132 years.
132. The operative portion is 136/5.2. One 36. This was settled long back, my lord.
So this should have been mentioned before the tribunal itself.
It is there in the order, tribunal's order. It was, original application was dismissed.
When was this dismissed? This was dismissed on the limitation issue?
No,
No,
No, on merits.
on merits.
on
But
13th of
that
February.
original application order was mentioned in page 137.
This was passed on 13th February 2023.
My lord. The petitioner created fresh cause of action, approached the tribunal. Tribunal also dismissed by holding lot of things.
Yes,
But this point was not considered.
the limitation point was
It
not
was-
considered.
My lord, not in so many words. But the order was reflected in the tribunal's order.
So how do you challenge limitation of the present appeal?
My respectful submission is that, my lord, the petitioner, after that parent order, he has not challenged that order, he accepted that order. Thereafter, he filed an application, created fresh cause of action.
Before the tribunal?
Before
So the
the tribunal.
tribunal ought to have dealt with it.
Yes. It was dealt by the tribunal.
Yes,
Against that, my learned friend filed the appeal.
yes.
So I am raising the preliminary objection stating that filing of the original application is itself is bad in law. Hit
The
by section
original
50.
application is not under challenge at all before this bench.
No, the order passed in the original application was challenged.
No, the.
No.
My development is supported. The way it was not maintainable, it was barred by res judicata, since this order had attained finality and it was not challenged by Mr. Singh's.
No, he says limitation. He doesn't say res
It's
judicata.
trying, because limitation in the sense that this order was not challenged, so therefore indirectly by means of this original application, they are trying to challenge this very order. So therefore it is barred, and although the tribunal has dealt with this issue, but he is saying that at the very threshold, the original application should not have been entered. That is his contention.
If my learned friend crosses that hurdle, my lord, then we will go into the merits of the case. To save the valuable time of the court, I submitted.
We have to go into merits to decide whether a fresh cause of action was created.
Without merit.
If you want to file an opposition, you can. Since you have. a
Everything
serious-
is there, my lord.
All documents are
Opposition is there, it's
Yes.
filed.
Nothing is required.
Everything is here.
In order to decide whether the matter is barred by res judicata or limitation, whatever you say, we have to go into merits. Isn't it?
Right.
You say he has created a fresh cause of action, whether it is a created fresh cause of action or in fact,
Continuing cause of action.
that has to be decided.
Yes.
If you are ready today, we can start.
Yes, my lord.
Yes,
Madam.
That was the one of the reasons why I have stated at the beginning, made my submission, that the facts of the case are necessary.
But there is one other aspect that Union of India is a party. So
not served.
So,
Where is the service? Union of India is served.
even otherwise also, there is an OM of 2012. It clearly says where the Andaman Nicobar Administration is a party, Andaman Nicobar Administration has to file an affidavit in opposition on behalf of the Union of India also. But here in Andaman Nicobar,
Serve the union. And
no, I have solved it.
Right.
But this objection they have been raising
where is the union?
time and again. No.
Where is the Union of India service? Union of India #1, where is it served? Bhavan, this is Lieutenant Governor. Yes. New Delhi GP, where is the postal receipt? Connected to the track. Where is your postal receipt? The track report is there, but no postal receipt to show that you've sent.
It was sent.
Where is
It
the
was
postal
received
receipt?
also.
Sir, the
I'll
postal
produce
receipt
it.
is
I'll
necessary.
produce it. I'll produce it.
And
I'll clarify this point also.
Save time, you can produce that postal receipt on the next day.
Next.
Will you inform, there is some learned counsel who is
yes,
present.
Mr. Tulsi.
Only on merit.
Mr. Lal is there. for
No, no,
the
this
so why
point
don't
they
you-
have been raising, my lord. They have been raising this point. This has to be clarified once for all.
Why don't
Because
you-
last time, what has happened in one of my case? I won the case from the tribunal. Union of India has come in appeal. They said, we have filed this reply before the tribunal. whereas the fact remains no reply has been filed before. No reply was filed. It is the Andaman Nicobar administration who are supposed to defend the Union of India. The procedure says that wherever the department, concerned department of the ministry, only one opposition has to be there. Otherwise, different stands cannot be taken on behalf of the Union of India. Say, for example, MHA is there, MHRD is there. In that case, Andaman Nicobar administration is there.
But the union may differ with the
No,
administration.
no. They may,
Several cases
Why not?
where separate
Why not?
lawyers represent, only in certain cases specific written instructions are received by the
I
administration.
I will place
The
it.
same lawyer will.
I will place it before your lordship because
Yes,
they-
but prior to that, I would request you to file the postal receipt, number one. And secondly, why don't you inform learned counsel who generally represents the Union
know.
of India? So that we can take up the
No,
matter
no.
on the next day.
why I am telling you, this is the normal practice here. Whenever the union, this case comes up before the, it has started very
The
recently.
administration doesn't agree with you,
No,
sir.
no,
Will you file a writ petition or some proceeding?
No, no.
For taking a declaration like this?
And you have.
whether the
implemented
Union of
them
India was
separately.
represented before the trial.
You have implemented them separately as a
No, no,
party.
if the Union of India was a party before the tribunal also,
Yes.
and they have been represented there also.
I don't have authority to represent today unless in certain matters
No,
I do.
Where
have
he has to have specific instructions on
Why
this.
not?
So without spending
No,
more
no,
time
I
on
will-
this, please serve and come back. Please inform learned counsel at least,
No,
so
no,
that he'll be able to appear.
because then the problem will come that he has to take the instructions from the higher authorities, from the
Necessarily he has
ministry.
to serve.
No,
He will not appear in his personal capacity, isn't it?
why not? These matters
The
particularly,
procedure has to.
no, no,
be
these
maintained.
matters, they are deliberately delayed. This is why I'm very seriously making this allegation. Very seriously, with all responsibility at my
Delay,
court.
I am afraid delay may have been on the part of the petitioner also who has
No.
not served as yet.
Why not?
Please do not make such suppositions. Please do not put aspersions on the. other
Then
side,
give me the
please.
time on Monday. I'll place you before your lordship, whether it has to be a
Counsel,
necessary party or not.
on Wednesday, let
Well, because last time this issue was taken up, then the division bench has decided 3 matters in my favor.
There is
Three
no such
matters.
decision. No, no, no. What
Yes.
is this? No, that those cases we received.
Well, we'll decide this matter on the facts of this.
Mine.
Facts of the case.
Uh, Since service upon the Union of India is not like. Since service upon the Union of India is not complete, comma, let the matter stand over till 18.
Mine.
And here in this case, what I have changed, not the orders. The order which has been shown, that has been never been implemented.
Never been implemented.
Never been implemented by Andaman Nicobar administration. No objection was raised by the private respondent.
Please come
No,
back, we'll hear it. Please come back, we'll hear it. Yes, next one.
Item 11.
I'm there for the. This is that matter where on the first day I have sought for upgradation, but the matter was retained in the same position. Now it has matured, it has come. Paper book has already been filed, now this can be taken up.
Yes, ma'am.
Yes.
I have not.
Not the just a gist of the matter. The applicant herein was serving as constable under the police department. He encroached a government revenue land.
This case also, my lord's union is a party. I am not certain if service has been done.
Service.
Let me check. I'll request in such a case, Lordship, to Mr. Kunsilal as has been done in the last matter also.
Please
because-
do that, please
Yes.
request it.
because
When
the
for
lo- But
service.
the thing is, Lordship,
Is
the
it
local
served?
administration is involved, the relief is against the Andaman Nicobar Police. Union of India, in terms of the CAT rules, have to be arrayed. It's not, Lordship, as anything with ministry concerned.
It may be recorded in the order, then we can proceed.
But then since you've implemented the Union of
I
India,
understand. I'll come back to that.
there should be a service. Please, request Mr. Lal.
No, instead of Wednesday, let it come on Monday, Lordship, sir.
No
It
difficulty.
is out of
No, I will make an
service for
effort.
13 years.
Otherwise, my learned, if
On
he
Monday.
can be heard, I can be heard on Wednesday in that case. No difficulty.
I'm grateful. Thank you.
I'll try to be there even otherwise.
Since service upon the Union of India is not complete, comma, let the matter stand over till Monday 16th. Short one.
It's a very short, not so. May I say in
Yeah,
one line?
The definition varies, that's the
Yes.
difference.
Paper book is so
Definition
thick.
of short and long varies actually.
The paper book you should not get in.
Because
because-
my learned senior is there for, because of his intellect, it becomes short. Its matter
No,
is
no,
not
no,
short.
no. Papers, voluminous would not, is compared. It should be very small and short.
Yes. Direction for? Yes, yes, yes. Affidavits are complete? Yes, yes. And let them appear in the list. Let them appear in the list.
Manoj, I have instructions here for the admins.
Without
Manoj,
file?
no copy.
Where's the file?
But item number 1, I am appearing on behalf of the petitioner, my lord.
The file has not reached this court as yet.
My lord, very unfortunate, but the petitioner are not getting any relief since my lord, the September 12th. My lord, the matter will be infectious because my lord, in terms of the order passed by the Honorable Justice Lobita Banerjee, my lord, the file has not been sent. My lord, petitioner is present before your lordship. Kindly, my lord, take up the copy of this writ application. My lord, your lordship is permitted so that my can place the matter because my matter will be
Taken up without the file, sir. Please ensure that the file comes next week. Yes. Please send in the requisition to them and ensure that it comes next week.
well, otherwise, your lordship kindly grant me to screen share through my lord the make my submission because
You have not solved also, sir.
well, yes, I have already served the with copies with me, my lord.
The island's administration?
Yes, everything served and again, my lord mentioned before your lordship and that letter has been sent to the all authority, my lord. You fixing your lordship today.
Might have served at the principal bench. Did you serve in Andamans?
Yes, I have served, my lord.
I don't know. We have not, my client, I had a conference
No,
yesterday also. They have not received.
They have not received any copy. Please find out, sir.
Okay, my lord, kindly take it up on 17th, my lord. My lord, kindly fixed on 17th. In the meantime, my lord, I is everything, my lord.
Let it
Let
appear.
it come, he'll be here.
Let it appear.
otherwise.
Let it appear. Yes, let it appear.
Well, Monday is my personal difficulty, so that I am placing my lord this my lord 17th, my lord.
Yes, yes.
In case I'm not there, my lord, he'll be
Yes,
here
yes.
and it can, I may be heard on the next day.
Yes, grateful.
Service is not complete. And the file has also not been received from the principal bench, comma, let the matter stand over till 17th.
Yes, ma'am. Grateful.
This is disposed of.
My lord, dispose matter, madam.
Yes.
I pay for the respondent.
Item 3. No order need be passed.
My lord.
Item 3, WP 889 of 2020.
Because I was, my lords, directed to get some written instructions, my lords. The instructions have been signed, my lords, but it is just on its way. So if my lords can pass over the matter. I know, my lords, it is embarrassing for me to request, but we have received, I have it in scanned soft copy, but the signed copy is just coming, my lords, it's on its way.
Not today.
Monday. Can I just add one thing on it? Let my learned friend obtain one copy by WhatsApp or internet, even if it's not able to come from Mayabandar due to the situation.
No, he says it's on the way. Yes.
He said this, but this
And you
was,
have 2 more days in between, so please collect the.
Yes, let it come on.
Not today.
My lords may just accommodate me on Monday if necessary, my lords.
Yes.
Otherwise I can, but my lord senior is there, so I have full.
no,
faith.
I have substantially argued the matter already. So it only remains for my learned friend to address with
Let
regard
the
to.
document come
what is
on
up.
Monday. If necessary, I will address on Wednesday.
This is where the work is complete. It's that matter.
No, no.
He's saying he's reaching in
Yes, yes.
5 minutes.
This is
So
where
if
the
my
work
lord
is
wants to pass over also, that is fine.
So I'll pass it over.
I'm at your lordship's convenience, so.
What is he?
Yesterday also this was said and it was.
He's reaching in 5
So
minutes.
by abundant.
Let it be
caution-
passed
Let it
over.
be passed.
Let it be passed
Fine.
over. I'm here, my lords. We can do the.
Item 4, WPA 905 of 2020.
4 and 5, my lord.
They are analogous matters, 4 and 5. I am for the petitioner in both the cases,
Yes.
Hearing for the first time.
and the affidavit of service has already been filed
I am appearing, my lords.
on behalf of the respondent number 7 only. 7?
No, I am appearing for the electoral officer. Technically, this deputy commissioner has to also be elected.
You are appearing for
Five.
5.
What about the others?
We have sent the copy to each and everyone by hand.
You are appearing for 5.
My lord. Mr. Sivabalan, if I'm not mistaken, is appearing for the revenue.
Where is he?
I'll just try to. He's here, Mr. Sivabalan.
You are appearing for the administration?
For respondent number
Provisional.
3 and 4, I think Mr. Sivabalan is up for the revenue department.
No, does not appear.
He is appearing. He appears usually.
And 1, 6 and 7?
One I'll appear, my lords. 2 also I'll appear. 6 I'll appear.
7 also?
7 he will appear.
7.
7.
So everyone is represented.
Yes.
Fine, yes.
My lord, the case of the petitioner is that is page 19. The purchase officer of the deputy commissioner's office has invited the 8 tenders at page 19.
Yes.
For videography production from the videography production companies and agencies for providing videography and photography teams for the coverage of the forthcoming parliamentary elections 2019. In terms of this 8 tender notice are submitted by 8 tenders, which has been accepted by them. And acceptance letter is at page 22. Page 22. It says, I am directed to refer to your e-quotations regarding the furnishing of the rates for the videography and photography teams for the coverage of the election related works such as enforcement of model code of conduct, defacement of public property, election expenditure and video surveillance for the conducting parliamentary elections 2019. The purchase committee of the department has accepted the rates quoted by me for the period 1/3/2019 to 29/2/2020. The terms and conditions are stipulated as in such and such. And he was directed to submit the performance guarantee of 50,000 rupees and non-judicial settlement. All these formalities were carried out. And thereafter, he has provided the teams. And after the elections are over, he has submitted the bills. All the bills have been submitted and it is not disputed. But till date, the payment has not been made. In spite of the fact, they have made representation to the Honorable Lieutenant Governor, to the Chief Secretary, to the electoral officer, and each and every one. First representation is at page 92, my. Page 92, annexure PY6.
Yes.
With reference to the above, I would like to submit the following. The that white letter dated 5/3/2019, Deputy Commissioner South Andaman informed that the RO/DC South Andaman has accepted the rates quoted by us for the work providing videography and photography in parliamentary elections 2019. That accordingly, we had executed the work and submitted our bills dated 30th April 2019, 30th April 2019, and 13th of May 2019. That as discussed in your chamber on 2nd of January 2020, we hereby submit that we are ready to reduce the 1% of the above bill amount provided the entire amount is paid within 1 month. Next, this is for your information and necessary action for releasing the amount after deducting 1% as agreed by us. As I took the finance to pay workers which I have to return soon with interest amount. However, if the amount is not paid within a period of 1 month, in which event we will be constrained to withdraw our concession of 1% as almost 10 months has passed.
None of your representations have been responded to.
Not responded.
Let us hear the response. Yes. 2019 bills. Why not cleared?
My lord, this is My lords, I can file an affidavit.
Not necessary at all. Clear the bills, sir.
My lords, the tender amount was, my instructions are tender amount was only for 10 lakhs or 20 lakhs and the total bills are running almost into a crore. Now the question,
Consider the representations
yes, my lord,
within 1 month.
my lord.
Yes,
I don't know. It is a case of 2019.
yes.
The bills have been submitted. I have agreed that 1% you can deduct it. Even then, I am running from post to pillar.
No, no,
They are
You don't need to run any further, sir.
My lord.
It will be disposed of within 1 month.
Yes, ma'am.
Yes, sir.
My lord, after that legal notice was given to them. That is at page, my lord, just for report. Last notice, legal notice has been given. That is at page 106.
Yes, yes.
The total amount in this case is 41,64,800.
800, right.
And they have paid me only 5 lakhs till date. The remaining is still pending. After giving this legal notice, they have not responded, except for the fact that a meeting was called. The meeting was held. Notice is annexed at page 109.
Did you attend the meeting?
No, I was not called. It is only a notice to me that a meeting will be held by the notice is addressed to Secretary Finance and Andaman Nicobar Administration District Election Commissioners.
That was on 18th August.
18th August.
My lord.
And now 18th August,
the
now we are
intention
in
is not to not pay.
October.
There's definitely, we are not taking an adversarial stand in this case, my lords. I think if my lords directs that, passes a direction, my lord, that will dispose of representation, my lord, that is.
Why dispose of the representation?
But
You
then
make
I
the
have to-
payment.
then I have to-
We do not know what impediment the authority is facing in payment.
Let them file an affidavit why they have not responded to
Why do you want to deal with the matter further, sir?
my lord. The question is.
Let
What
them
will-
consider within a month.
Yes, yes, my lord. That will be done.
Affidavits will take you to maybe the next or
Next
the
year.
circuit bench thereafter.
My lord, in that case, they will have to give an explanation why my representation was
They
not.
hear
considered.
you. You will be given an opportunity of hearing by the authority. It is only after that that they'll pass an order.
Yes, yes.
They have to give you an opportunity of hearing. You can place all your documents before the authority. Yes, do you agree to that?
R7,
No, no.
R7.
Why I am saying so, my lord, the interest amount has accumulated too much.
That's why, that's
have borrowed
exactly
the
why
money.
I say let the authority decide. The
Because-
court cannot direct the authority to pay interest. We do not even know.
No, this is a admitted fact. Let them say, let them come with the shorter instructions whether they have to make the payment or not.
Well, if you're interested, if you say
Then
so,
we have
next
to file
circuit,
an affidavit.
next circuit. I was actually I wanted to dispose of the matter
No, no,
and give you some relief within 1 month.
why not then just pass on, just for 2 minutes. My client will be coming. Otherwise, he will say why you have got it. I'll get it.
Isn't it? I think that will make you'll have a speedier justice. Appear before the authority, I'll direct them to do whatever necessary within 1 month and they'll hear you.
And I can say informally without it being recorded that this is not, there is no intention not to pay them what is due to
Cannot
them.
be, cannot
That is
be.
not
It's the
the
authority,
intention,
it's not a private individual.
Yes. So my lords, if certain.
The biggest shocking thing is in the welfare state 2019, they have taken the work.
I've
from
seen
me.
that, I've
I
seen
have
that,
to.
I've seen that. You want a passover?
Just, I'll just call my,
5 minutes
Fine.
passover.
both the matters are
Both the
same.
matters, right. Let it in.
I'll just come
Right, right.
in 2 minutes.
4 and 5 passover.
Man.
Item 6, WPA 941 of 2023.
6, I will be appearing for the respondent authorities, respondent number 1, 2, and 3 only. Private respondents are there.
Petitioner? Who is appearing for the petition? Mr. Jayapal is appearing.
Yes,
for the
madam.
petition. Where is he?
He was here.
Pray for Mr. Jayapal short pass.
All matters cannot be passed over. Service complete.
No, madam, there are private respondents. I am appearing for official
Where is
respondent.
the service on the private respondents?
Proxy.
The file, please.
Court number 2. Mr. Jayapal is court number.
Yes, but what about private respondents? There are 2 private respondents. The two, passed over,
Obliged, my lord.
passed over.
Item 7 WPS 967 of 2023.
My lord, item number 7, it's a case of Diglipur Island. So I pray, my lord, let it be on Wednesday. I've already dispatched. Speed post I have done. You have not received? Very, not yet received. Since service upon the respondents is not complete, comma, let the matter stand over till 18. Obliged.
Item 8 WPS 968 of 2023.
This is the same.
I pay for respondent, my lord.
He is a quotum.
Passed over.
Item 9 WPA 969 of 2023.
You say I put the petition it is a electric connection matter.
Yes,
Your lordship, my client has applied to the authority. This is on page 10, P2.
who is appearing for the respondents?
well,
You are appearing?
Well,
You have applied for connection, P2.
P2. 12515 application number dated 20 March 2023.
Yes, what is the difficulty?
I don't know the status. It's not. If it is covered by the judgment, that has to be.
Yes,
But he's swearing an affidavit that he is the encroacher of the revenue land. No, not revenue, encroacher. Revenue. No. Encroacher. No.
it is your own property.
No.
Then revenue land,
Government.
encroacher.
Your encroacher. Somebody will come forward and say, this is my property and this is not. So the revenue is the appropriate property.
No,
You
no,
may
why
charge.
don't you see the relevant documents when you produce the,
I am the only service provider, my lord.
documents have to be provided by the petitioner to substantiate that it is his property,
My lord, there is no record. has
at
been
least
placed.
possession.
Position, some.
No, when the application is considered,
My lord.
let the petitioner be heard and let the petitioner produce relevant documents before you.
My lord.
They
Right.
may inspect, they may inspect, they may
Yes,
inspect.
yes.
My lord. My lord.
The petitioner claims to be in settled possession of government land, being survey number 418/1 within bracket P, measuring an area of 200 square meters in village Wimberleygunj. Stop. The petitioner applied for electricity connection in the said property before the concerned authority on 20th March 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the application at the earliest and provide electricity connection to him in the property in question.
To her.
Oh, it's a her, to her in the property in question. Yes. Paragraph. It is trite law that an occupant in respect of a property, comma, even if she be an encroacher thereon, comma, is entitled to electricity connection therein until she is evicted in due course of law. Paragraph, since the petitioner claims to be in settled possession of the plot in question, comma, the writ petition is disposed of directing the assistant engineer,
Well, yes.
directing the third respondent to consider and dispose of the application filed by her dated such and such within 4 weeks.
Right.
Or within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Stop. The petitioner is at liberty to place all relevant documents before the authority at the time of hearing in support of her claim. Disposed of those 4 lines.
Highly obliged.
Item 10, WPA 74 of 2021.
My lord, I am appearing for the petitioner. This is that matter. I just narrate the fact, my lord. Here, these petitioners are working from 93 to 96 onwards. They have been engaged. Subsequently, my lord, the administration has mooted a proposal. On the basis of the proposal of the administration, after the intervention of this writ court, my lord, the ministry has approved, and on the basis of such approval, supernumerary posts were created, and the effect was given from prospective instead of retrospective effect. And I have placed the judgments of this court and the order passed in the case of Home Guard, whereby the same administration has given the benefit from the date of initial engagement.
Yes, my lords. My lords, in this case, my lords, initially, my lords, I had submitted on the last occasion that in view of the Supreme Court's order, which was placed before lordship in a different case. My lords, the issue of regularization is now by 30th November, the administration has to come out with a scheme. Now, the scheme of regularization from the affidavits filed before the Supreme Court and the order of the Supreme Court would apply to casual workers and DRMs. Now, the question in this case is these, admittedly, the petitioners were also working as DRMs, daily rated Mazdoors. However, subsequently, on the recommendation of the administration, my lords, they were supernumerary posts were created. Now, supernumerary, this matter involves the question of what is a supernumerary post. A supernumerary post, my lords, is not a permanent post, and it is only a temporary arrangement until a post is created.
Right.
So it is arguable to say that they are not even now, even as on date, they are still ad hoc employees. The post has been created to give them the benefits of a regular worker until a regular post is created. Now, my lords, I'm carrying so therefore, my lords, there are two submissions. One is that, my lords, here the issue is that the date from which they have to get the benefit. Now, my lords, one is that if this can await till 30th of November, because they may be entitled to regularization, or whether the scheme that is brought in will also cover people who are holding supernumerary posts. That is a question which is still uncertain. So one option is, my lords, to adjourn it to after, my humble submission, I'm saying, that to adjourn it to after 30th of November. Otherwise, my lords, if that is not acceptable, then, my lords, I will address, my lords, on the merits, because, my lords, according to me, in my humble submission, my lords, because there is if benefits are given to them from the date of their appointment, that will impact the regularly appointed persons. Now, I'm carrying judgments of the Supreme Court, where the Supreme Court has said that supernumerary posts cannot be treated at par with regularly appointed persons. And in fact, there have been cases where a separate list is created for people who are appointed to supernumerary posts. So, my lords, if they are given from the date of their appointment, they will impact regular appointees or persons who are appointed through the course of regular recruitment. So that will create a problem, my lords, and I am armed with judgments. Of course, I'm sure my learned senior will also address arguments on the point. So, my lords, I am submitting at the first instance that it can wait till.
Can we wait till 30th November?
My lord, this is absolutely on a different prospect, my lord. If my lord sees, here is a case of violative of Article 14. I am saying that it's a discrimination. The argument which my learned friend is making, my learned friend at this junction cannot make that argument. Once my learned friend, being the same administration, has given the said benefit to one set of employees under the administration.
They were also holding supernumerary
posts, my lord. So this argument my learned friend cannot make. The state, we are in a welfare state, such type of arguments, this is discrimination. My lord knows very well, my lord, when the question of discrimination comes, even the law aspect is not required to be decided at all. My lord has to see whether there is a discrimination or not. Once it is discrimination, the law point can be kept open with regard to some other cases which involves law point. This is the settled preposition of law, my lord. And my lord will find from the order that it is a supernumerary post. And my lord, the supernumerary post, what my learned friend says, that is not the exact position of law. Supernumerary post is created and the supernumerary post exhausts when the incumbent dies. It is not that it is an interim argument.
Carried forward.
It cannot be carried forward. It is not
one aspect.
That is one aspect, my lord. What my learned friend is saying, that supernumerary post is an interim arrangement and it will be created. It is not like that. Once the incumbent dies.
Supernumerary posts are, so far as my little knowledge goes, not regular posts.
It's not a regular post. It will be in existence till that incumbent survive or he attains the age of superannuation.
He is regularized.
No, my lord, my lord, here when supernumerary post is created, because my lord, it was created.
Supernumerary post is a beneficial registration
My lord,
which allows the incumbent to join.
Join.
Earn.
Yes, my lord,
Yes.
yes. No, my lord. Supernumerary post is created for the purpose when an incumbent is working for years together and his service was not regularized only because there is not a permanent post is not created. Under such circumstances, taking into consideration the years of service which he has rendered, my lord, the authorities create supernumerary post, my lord. It is not that one fine day they will create supernumerary post. Supernumerary post will be created only if an incumbent is working under the authorities for years together.
Yes.
So, my lord, this argument, and I am not arguing on merit. I say that it's a clear case of discrimination. Discrimination. I am not arguing on any law. I am saying that it's
not addressing on merits yet. I am only submitting that, my lords. So as my lord had observed, my lords, admittedly, my learned senior will not dispute, my lords, he is an authority in the field.
No, it's
That
not.
supernumerary post, there is two situations, either when the person dies or he is given a regular appointment. So, my lords, today the administration is coming out with a scheme for regularization. Now, that we don't know, my lords, conceivably that will also, if it is covering DRMs and casual workers, my learned friends' clients may also be entitled to apply under that. So, my lords, that is why I was only submitting that this can await till 30th of November. Otherwise, I'll address, my lords. I'm ready to argue. I'm not saying that.
My lord, my respectful submission is that scheme has got nothing to do. If my learned friend is arguing today, what my learned friend is arguing today, let my learned friend demonstrate that at any point of time, the name of my clients were proposed for regularization because it is on the process.
No, it's not a question of proposal. It's a scheme which will come and see the light of the
for the purpose of scheme, my lord, in terms of the order of the Supreme Court, ultimately
scheme covers your client also. So he'll have the opportunity.
My lord, what happened, my lord? Supreme Court said, no, I'm sorry, I will correct it. Before the Supreme Court, they said that we will frame a scheme by 30th November 2023.
Yes.
And they said that we will regularize the service of all those who completed 10 years of service on 1st of August 2023. And for that purpose, all the departments started sending the name of those persons who qualify within the said scheme.
Is that the submission?
Yes, absolutely, my lord. This is the submission.
Scheme has not been published till now.
No, I am not on that. I am saying that
anyway, he would qualify under that also.
My lord, for the purpose of that has to be placed. Now, my lord, all the other departments who completed 10 years of service, their names were sent to the authorities, to the Andaman Nicobar administration, so that their service will be regularized on and from 30th November onwards, my lord. Our name was never sent. Let my learned friend take instruction and come back at any point of time. The name of these persons were sent to.
This is
no, my lord. My learned friend is making an argument which is contrary to the stand of the administration.
Then I have no problem. I'll argue the matter.
Yes.
So, my lords, may first have, my lords, the order. And today, my lords, there are judgments of Supreme Court that the writ court cannot direct creation of supernumerary posts also. But I'm not today, my lords, we have much water has flowed.
The posts are in existence.
So, pursuant to a court order, my lords, technically this order may be in breach of the Supreme Court's latest judgments. My lords may see 27th August 2019 order, which is at page 26 of the writ petition. This is writ petition number 187 of 2019. Order of 27th August 2019. 29 petitioners have
page 26.
56 of the annexure P4 of the writ petition. 29 petitioners have petitioned for issuance of mandamus. My lord has page 56 in the writ petition.
Yes. 187 of 2019.
Yes, ma'am. Yes, ma'am. 29 petitioners have petitioned for issuance of mandamus directing respondent authorities, particularly Government of India, for creation of supernumerary posts to regularize their services within a time frame. Mr. Kumar, learned advocate, appears on behalf of the petitioners and submits the administration filed a report dated 16th August 2019, which carries correspondence already disclosed in the writ petition. He submits that all queries raised by Government of India have been satisfactorily answered by the administration, and there should be directions as prayed for. Mr. Mundol, learned senior advocate, appears on behalf of the administration and relies on said report filed by his clients. It appears from the report that initially by letter dated 18 March 2016, clarifications / information on 3 queries were required by Government of India for further examination and creation of supernumerary posts is not clear. I think 29 or 32 workmen's creation has not happened. Last document enclosed is letter dated 22nd January 2019. addressed by the administration to Under Secretary. On perusal of correspondence enclosed in the report, it appears the administration maintained throughout that some of 32 workmen were engaged to employment exchange, others on daily rated basis and thereafter casual basis. They have since completed 20 years and their services were are essential to Directorate of Information, Publicity and Tourism to meet functional requirements. Government of India, and following up with several queries, indicated not a fit case for creating the post. In the circumstances, respondent was directed to make his decision on the issue known within 4 weeks of communication as order. It is expected that decision, if is in the negative, will carry reasons in support of it. So, my lords, this is the origin because of this order, my lords. After that, my lords may have my affidavit in opposition. Pursuant to this order, eventually, my lords, these posts were created. And the issue here is whether the service benefits are to be given from the date of appointment. Now, my lords, what is a supernumerary post? My lords may have my affidavit in opposition.
Yes.
We have annexed the relevant circulars, etc. of the Government of India. And my lords may first have page number. Annexure R1 will show, my lords, that this is the office order.
Yes.
Whereby the benefit of 1/30 was given to these people. After this, my lords may come to page number 21. 21 is the order regarding creation of supernumerary posts. My lords may just see this to complete the factual submission. The Director IP&T is pleased to appoint following 29 persons on supernumerary post of workmen with effect from 21st November 2019 in the level 1 of rupees such and such in compliance with the order of the, which I just shown, 27 August 2019, and with approval of Ministry of Home Affairs on subject to the following terms and conditions. My lords, the first 4, of course, declaration, etc. Now, my lords may see para 5. Appointment will be on personal basis and these posts will be abolished once they fall vacant on account of retirement, death, or any other reason. He may not be required to serve in Andaman and Nicobar administration as well as pension scheme applicable in respect of matter not specified will be governed by relevant rules applicable to similar employees. And my lords will then see next page, ministry is approved, etc., etc. This is the appointment. Now, my lords may next see 21st November 2019, my lords, order issued by the Government of India Ministry of Tourism. Now, my lords, see this is specific to these petitioners. This is being communicated in compliance of the order. Now, my lords will see this order which I just read at page 21.
Yes.
Refers to the order of the Ministry of Tourism, 21st November 2019, and this is the order of the Ministry of Tourism, whereby these people were supernumerary posts were created in their favor. Now, my lords, let's just see this. This is being communicated in compliance of Honorable High Court Calcutta Circuit Bench order such and such. Proposal of Andaman and Nicobar administration forwarded by Ministry of Home Affairs was considered and consultations were made with Department of Personnel and Training. Undersigned is directed to convey approval of competent authority for creation of 32 supernumerary posts for regularization of workmen working in Andaman and Nicobar administration subject to conditions laid down in para 4 of Department of Expenditure, which are not. This is very important, my lord. Supernumerary posts following, this is subject to these conditions, these posts have been created. The following principles should be observed while creating supernumerary posts. The supernumerary posts are created for the purpose of accommodating the lien of a government servant who, though entitled to hold a lien against the regular post, cannot be accommodated because of non-availability of such a post. B. The supernumerary post is a shadow post. That is, no duties are attached to such a post. The supernumerary post is created for a definite and fixed period. Such a supernumerary post is created for accommodating an officer till he is absorbed to a regular post. It should not be created for an indefinite period. This is exactly what was observed by your lordship. The supernumerary post is personal to the officer for whom it is created, and no other officer can be appointed against such a post. It stands abolished as soon as the officer for whom it was created vacates it on account of retirement or is accommodated in other regular post. In other words, no officiating arrangements can be made against such a post. Administrative authorities should maintain a record of supernumerary posts, the particulars of the individuals who hold lien against them, and the progressive abolition of such posts as and when the holder of the post retire or are absorbed in regular permanent post for the purpose of verification of service or pension. So, my lords, the intention is very clear. This is only a temporary arrangement. When an individual gets absorbed into a permanent post, these questions will arise. That is from the date from which the benefit is to be given, service benefits are to be given, etc. So, for example, when an ad hoc employee gets regularized, this same question arises. There, my lord, then there are decisions which say that if the courts will hold, will through an adjudicatory mechanism, courts have held that if you are appointed against a grade pay against a particular pay scale, then maybe even your ad hoc period will be counted. But my lords, if that is not the case, then my lords, that at that stage, my lords, the court will consider this question. When the regular appointment is given, that maybe at that stage the court will say that today you are given regular appointment, but earlier you were appointed as against a supernumerary post and that supernumerary post appointed you against a particular grade pay. So therefore, that period should be counted. But these questions will arise only when a regular appointment is made, not on the strength of a supernumerary post, which is only a temporary arrangement. Now, my lords, we have the next page, page 25. Now, my lords, the Government of India's decision is, my lords, recorded here. The following principles should be observed while creating supernumerary posts under Rule 11(2). 1. The supernumerary post is shadow post, i.e. no
Page
duties.
25.
25, my lord. Next page. My lord has page 20.
25 is the OM number 51016. That is 25. R4.
No, my lords has annexure R1. The opposition.
Yes.
Opposition, my lord.
R1 is order number 1115.
My lords, what is the after that 21st November 2019? What is the next document?
13th March 2020, which you've read out. Then 21st November 2019.
Yes, my lords.
Yes,
After that
is R4, which is grant of temporary status and regularization of casual workers. That's R4.
now, my lords, I will just
10th September 1993 order.
Yes, my lord. Anyway, my lord, this portion which I just read, this is set out in the 21st November order. I'll just hand over then, just for your lordship's convenience. This Government of India's decision, it's also annexed to the writ petition. My lord, I'm just handing this over for your lordship's convenience. This is also part of the writ petition. It's annexed. So I can in fact. So, my lords, these are the principles, and this is what was set out also in that letter, which I had just now read.
Yes, yes.
I'm just reading out for the convenience of the court. Government of India's decision, the following principles. This is in fact annexed with the writ petition also. It's not a new document. I'll just point out I'll just read it while it's the official document. There is no problem. The following principles should be observed while creating supernumerary posts under Rule 11(2). The supernumerary post is shadow post, i.e. no duties are attached to such a post. Officer whose lien is maintained against such post performs duties in some other vacant post, and accordingly, it should not be created in circumstances which at the time of creation of the post or thereafter would lead to excess of working strength. As a supernumerary post is a post created for accommodating a permanent officer till he is absorbed substantively in a regular permanent post, it should not be created for indefinite period or other permanent posts but should be created for definite and fixed period sufficient for the purpose of in view. It is personal to the officer to whom it is created, and no other officer can be appointed against such a post. It stands abolished as soon as the officer for whom it was created vacates it on account of retirement or confirmation in another permanent post, or for any other reason. In other words, no officiating arrangements can be made against such a post. Since a supernumerary post is not a working post, number of working posts in a cadre will continue to be so regulated that if a permanent incumbent of one of the regular posts returns to the cadre and all the posts are manned, one of the officers of the cadre will have to make room for him. He should not be shown against a supernumerary post. No extra financial commitment is involved in the creation of such a post in the shape of increased pay and allowances, pensionary benefits, etc. This is all very relevant to my argument. Administrative authority should maintain a record of supernumerary posts, the particulars of individuals who hold liens against them, and the progressive abolition of. So therefore, my lords, this is only a temporary measure to give succor to the employee, and it should not result in any disturbing the general order of things. Because, my lords, if any benefits are given from the date of appointment, it will affect the seniority of others. It will result in increasing financial burden. So all of these things are to be taken into account and should not be disturbed by the creation or functioning of supernumerary posts. Now, my lords, will see likewise the 10th September 1990, my lords, scheme is also annexed, my lords, at page 25.
Of the opposition?
Yes, my lords, opposition. My lords, that the reason why it has been annexed, my lords, I just explain that.
25 is an order of 1993.
Yes, my lord. Now, my lord, these are the guidelines in the matter of recruitment of paper on daily wage basis in central government offices in terms of the OM of 7 June 1988. Then, my lords, will see. So, my lords, will see on the next page, page 26 is the appendix.
Yes.
This at the relevant, so which is why I was submitting, my lords, that when a new scheme comes in, that will also have an effect. So at the relevant point of time, this was the scheme. So, my lords, under this scheme, my lords may see this scheme shall be called Casual Laborers Grant of Temporary Status and Regularization Scheme 1993. This scheme shall come into effect from 1993. This is applicable to casual laborers in employment of ministries, department, and their attached and subordinate offices. Temporary status. Temporary status would be conferred on all casual laborers who are in employment on the date of issue of this OM and have rendered continuous service of at least 1 year, which means they have engaged for a period of 240 days. Such conferment would be without reference to creation and availability of regular Group D posts. Conferment of temporary status on casual labor would not involve any change in their duties and responsibilities. Their engagement will be on daily rated basis. Such casual laborers who acquire temporary status, however, be brought onto the permanent, will not, however, be brought onto the permanent establishment unless they are selected through regular selection process for Group D posts.
This is different from the supernumerary posts.
No, this is the usual course of things. So what I'm submitting is that as on date, this is the last available scheme. So under this last, admittedly, but for the supernumerary posts, they are temporary casual workers. So temporary casual workers are guided by this scheme. So this scheme provides for the manner in which their services may be regularized. Now, therefore, the horse of the, my lords, may just see, my lords, point number 8 at page 27. Procedure Group D posts. If these people are regularized, they would be regularized to Group D posts. That is the posts in the government which are applicable to people who are carrying out this kind of work. 2 out of 3 exist. Every 3 vacancies in Group D cadres in respective offices where the casual laborers have been working would be filled up as per extant recruitment rules and in accordance with instructions issued by Department of Personnel and Training from amongst casual workers with temporary status. However, regular Group D staff rendered surplus for any reason will have prior claim of absorption against existing future vacancies. In case of illiterate casual laborers or those who fail to fulfill the minimum qualification prescribed for post, regularization will be considered only against those posts in respect of which literacy or lack of minimum qualification will not be a requisite qualification. They would be allowed age relaxation equivalent to period for which they have worked continuously. On regularization of casual worker with temporary status, no substitute in his place will be appointed as he is not holding any post. Violation of this would be viewed very seriously and attention of the appropriate authorities would be drawn. These guidelines are issued in terms of OM. So, my lords, this is the scheme under which their services would be regularized in the ordinary course. And now, therefore, in the meantime, this today under the Supreme Court's order, there is a fresh scheme which is being contemplated.
Which is underway, yes.
Which is underway. So when it is, so therefore their status until such time or unless they are regularized in terms of the new scheme to be brought in is no different from that of a casual mazdoor, unless except for the fact that under certain court orders, this benefit, because they have been working for a very long time, this benefit of supernumerary post has been given to them. So their status on being appointed to a supernumerary post, their status doesn't become that of a regular employee. So, my lords, they can enjoy the benefits under the supernumerary post unless they are regularized or they retire. So, my lords, what they are seeking here indirectly, my lords, is to seek the same status as a regular employee. Now, my lords, today, tomorrow, if they are regularized, then these questions will arise that the benefit date from which the service benefits are to be given.
And they say that the same benefit has been granted to home guards.
Yes, this is my case. This is the what
He's
Gauri has
seeking
put by
parity,
the
that's
court.
all.
Yes.
Where are those orders granting benefit to the home guards?
My lord, actually, my brief, I'm just placing it, my lord. My lord, it starts from page 113. What was brief?
Of the writ petition?
My lord, at 113, annexure P13. Supernumerary post.
This is also in compliance with the court order.
My lord.
And my lords may notice that this is the
My lord,
case.
my learned friend is arguing many things. My lord, that is not the subject. I have not raised any issue with regard to the nomenclature, what is supernumerary post. I am not on that. I say we are the two children of the same authority.
He is seeking parity.
Parity, well, and my lord, I will show one judgment of Supreme Court in which, my lord, some of the drivers were given, suppose 50 drivers were appointed, my lord. Subsequently, they recognized the service of 20. I went before the tribunal. I said that this is a clear case of discrimination. Tribunal accepted my argument. High Court accepted my argument. When it went to Supreme Court said nothing doing. When you have given one set of people the same benefit, then definitely we are also entitled. And the Supreme Court in the last paragraph has written that, my lord, the question of law is not decided. Supreme Court said, there are equally circumstances, you give them appointments. After that, they have appointed. I am on the same parity. I don't want to say anything with regard to law. I say, my lord, when we are equally circumstances, why this discrimination? This is the only argument which I have made, my lord.
My lord may just have this order which my learned senior has shown at page 113. This is a case of regularization. My lords may see what this reads. It says that in compliance of the ANN administration order passed by Supreme Court, following home guards and similarly placed home guards home guard are hereby regularized in the supernumerary posts.
Yes.
So they were appointed to a supernumerary post at an earlier point in time. They were subsequently regularized from the date of
not read the brief, perhaps. What is making contrary to the facts.
And in any event, my lords, these orders, if my learned friend, my learned senior places the orders, I'll address it. But my lords, my submission is, my lords, that today there is no question of regularization. They are not regularized. The scheme for regularization is still in the making. So they have been appointed to supernumerary posts. They are enjoying the benefits of supernumerary posts.
The scheme for regularization of supernumerary posts is not in the making.
No. The scheme, according to me,
I mean, we
will
don't
also
know what is there in the scheme. I mean, whether it covers the restrictions at all.
It will cover, because my lords, persons who are appointed supernumerary post does not change their character of being a DRM. So according to me, my lords, it may perhaps cover them also because they are covered under casual
At page
labor.
113, the supernumerary posts have been regularized in the supernumerary posts.
They have been regularized. That is it has been done in no, but how can then I'll come to the law, my lords. I'll submit that, my lords, this may have been done at one point of time, but my
And
lords,
this is not under challenge.
no, this is a done in the case of some
2009,
this is done
yes.
with some other people. It is not, does not make it correct. It
Similarly
doesn't-
circumstanced.
No,
There
that's
were
my
300 and odd, my lord. I am only
know what
When
was going to
one
it.
set of
My lord.
persons being appointed in the
My lord.
supernumerary post gets regularized in the post.
My lord.
from the date of initial
My lord,
appointment.
since 2009, my lord, the law has also changed, my lord. Today, my lord, there are so many judgments where regularization direction only cannot be given by the writ court, my lord. Those I'll have to place. I have to address this case, my lord. I don't know what was argued and what was done in.
Come back with further instructions in that case.
My lord, there is a pleading. What my learned friend submit, maybe my learned friend is burdened with briefs, therefore he has not read it.
Very well, I will.
But the thing is that there is a pleading to that regard. They have counter it. At this junction, my learned friend cannot say these things.
No, I will just place the judgments, my lord.
And I am not arguing on merit. I say that this is a clear case of discrimination.
No, I can,
Yes.
I'll just address I'll show the judgments, my lords.
So you'll come back,
No, I've got the judgments. I've got everything. I can argue, my lords. I have no difficulty. So my lords may then see.
the preliminary question is, this order. He has based his argument only on this order.
Yes, yes, ma'am.
So
That's
then let my learned friend place all these.
No, I have
judgments on
nothing
what-
but this is my
Order
case.
per se without the judgments pursuant to which this order was passed does not.
Everything is part of the writ petition. Everything is part of the writ
My lord-
petition. There is a pleading to that effect.
No,
All the judgments were
No,
annexed.
I will place the judge. My lords may see the first judgment that I'm relying upon, my lords. Is,
This was in compliance with one judgment of of this court, MAT 25 of.
My lord, that is enclosed, my lord. That is the
2006.
part of the writ petition, my lord.
And another judgment of the Supreme Court,
Yes,
10 for SSC, 10
my
for
lord.
6.
Again,
Where are
again,
these two
my
judgments?
lord, these are the part of the writ petition, my lord.
Page,
I'm just pleased. My lord. Division bench judgment was passed by Honorable Justice, presided over by Honorable Justice Jyotirmay Bhattacharya, my lord. I'm just placing it. Yes. My lord, kindly come to page number 92, my lord.
yes.
This is the judgment of the division bench, my lord. Now, my lord, kindly come to
may I place the judgment with your lordship's permission? I'll read the.
this is
My lord may see this page 92. In this appeal, we are called upon to consider and examine the scheme. PIZ Home Guard Regularization Absorption Appointment of Andaman and Nicobar Administration 2005 to ascertain as to whether the said scheme was framed by the administration in conformity with order passed by another division bench of this court on 16 December 2003 in WPCT such and such, heard analogously with WPCT such and such and such. By the said order, direction was given to the appropriate authority, VIZ Andaman and Nicobar Administration, to frame a scheme as per direction of learned tribunal passed in its order dated 16 September 2002. Division bench also directed the concerned authority to take into consideration principles laid down by Supreme Court in state of West Bengal versus Pantho Chatterjee and others. The said order of division bench was challenged by the official respondents before the Honorable Supreme Court in special leave petition, being petition was civil appeal primarily on the ground that principles laid down in Pantho Chatterjee's case cannot be applied to the case of the petitioners. Petitioners are not similarly situated. The special leave petition was dismissed by the Supreme Court, meaning thereby the directions passed by division bench in earlier writ petition as referred to above are required to be carried out by the administration. A scheme, VIZ Home Guard Regularization Absorption Appointment Scheme, was ultimately framed by Andaman and Nicobar administration when the administration was compelled to do so by an order passed in contempt proceedings initiated against the administration official. Challenging the scheme, a writ petition was filed by the appellants contending that the scheme was not framed in conformity with the directions passed by the division bench of this court in the earlier writ petition. The appellants prayed for issuance of mandamus for cancellation of scheme and for absorption of the petitioners in terms of directions passed by the division bench in earlier writ petition as mentioned above. By the impugned order, the learned trial judge rejected the said writ petition by holding inter alia that the scheme was formulated by the authorities in accordance with decision of division bench and also by following directions passed by the Supreme Court in state of West Bengal versus Pantho Chatterjee. The learned trial judge held the reservation of 20% of the vacancies occurring in any year, including existing vacancies in all the posts in Group D in ANN administration and the post of constable in Group C under the ANN Police Department for the Home Guards who are presently enrolled and have rendered at least 5 years of continuous service or more and fulfilling the eligibility conditions, including educational qualifications prescribed in recruitment rules, Andaman and Nicobar Police Manual, and the continuation of such reservation policy till the total absorption of the petition in service are just and illegal, as 100% reservation of the vacancies for the writ petitioners is demanded cannot be accepted, inasmuch as 100% reservation is opposed to public policy. The learned trial judge further held that if 100% reservation is provided for the petitioners, then the other candidates of reserve category, that is scheduled caste, scheduled tribes, OBC, etc., and or candidates from open category will lose their right even to apply for such vacancy. Thus, let us examine as to how the learned trial judge was justified in arriving at such conclusion. In order to examine whether the scheme was framed as per direction of division bench in the earlier writ petition or not, this court is required to place on record the directions passed by the tribunal, which the authority was required to adhere to at the time of framing of scheme in terms of directions of division bench. The directions of the tribunal are as follows. The respondents, and in particular respondent number 1, shall consider framing an appropriate scheme in consultation with the AN administration for absorption, regularization, appointment of persons like the appellants who have been working as home guards for a number of years and for connected matters. They shall also keep in view observations made in para 7 above while framing the scheme to sort local conditions, keeping in view the particular facts and circumstances of the case. For the sake of convenience, para 7 of the order of the learned tribunal is also set out below. It is recollected by one of us that the tribunal had considered a number of cases of home guards who have been employed by the NCT Delhi, who have also claimed similar benefits under the provisions of relevant home guard rules applicable to Delhi. The same pleased that home guard is a voluntary organization. It was not meant as full-time employment. There was no sanctioned post and therefore there cannot be any regularization. However, in furtherance to directions, writ petitioners were filed in which certain directions have been given by the Honorable Delhi High Court also to respondents to prepare a scheme to cover the home guard in similar situation. We consider that in the circumstances of the case, it would be appropriate for the respondents and in particular respondent NCT Delhi to together with through the Ministry of Home Affairs to contact government of NCT Delhi together with relevant judgments and the tribunal on the subject so as to examine so that they can examine the issues raised in the present two applications in a similar fashion. Consequently, government of NCT Directorate of Home Guards has also prepared a scheme as per the directions of the court to deal with similar issues which may in these circumstances be seen and considered. Since the division bench while disposing of the earlier writ petition directed concerned authority to frame the scheme as per the aforesaid direction of the learned tribunal and also by taking into consideration principle laid down in Pantho Chatterjee, we also think it necessary to set out directions to be given to the respondent herein in Pantho Chatterjee's case. Part-time members of border wing home guards would be treated as at par with full-time staff. They would get all privileges on state armed police, all the benefits available to West Bengal government servants, for example, fixation of pay, benefit of PF, gratuity, ration, and allowances and leave shall be made admissible. Areas of service benefits are also directed to be given. They are also directed to absorb irrespective age bar. Let us now examine as to whether the concerned authority adhered to the directions. Now, therefore, my lord, this scheme is set out. Mr. Ray, learned senior counsel advocate appearing for the official respondent, submitted that the impugned scheme was formulated in conformity with directions of learned tribunal. Mr. Ray further submitted the authorities were never directed by the earlier tribunal to frame the scheme in light of directions issued by Supreme Court of Pantho Chatterjee's case. Mr. Ray further contended division bench while disposing the earlier writ petition simply directed concerned authority to take into consideration principles laid down. Mr. Ray thus contended that said part of the directions cannot be considered mandate upon the authority to frame the scheme by following principles laid down in Pantho Chatterjee's case. Mr. Ray further contended that since the petitioners herein are not similarly placed like petitioner Pantho Chatterjee's, the principles laid down in Pantho Chatterjee's case cannot be followed. We are, however, unable to accept the said contention as were not accepted by Supreme Court. Mr. Ray further contended since specially petition dismissed, it cannot be held that contentions were not accepted. We cannot accept the said contention as settled law. The order of dismissal of specially petition in limine merges with the order under challenge in the said SLP, and the order passed by Supreme Court is final and conclusive. Then, my lords, these judgments are on next page 19 judgments. On careful consideration of orders passed by learned tribunal, the earlier division bench, and Honorable Supreme Court, we have no hesitation to hold that concerned authority is required to frame the scheme not only as per directions. If that be so, we have no hesitation to hold the said directions were not followed by the concerned respondents by framing the scheme. Neither the tribunal in its aforesaid order nor Supreme Court in Pantho Chatterjee's case directed the concerned authorities to frame a scheme by absorbing the petition in installments. Absorption means regularization. Absorption and regularization and new appointment are not synonymous. In case of new appointment, employer cannot ignore the principles of reservation. As such, we cannot agree with the time. As a matter of fact, absorption in installments by introducing none of this is relevant with this next para. We see the spirit of the order of the tribunal as well as earlier division makes it clear the benefits given to the petitioner said order should be extended to all petitioners uniformly and without making any discrimination amongst them. If the absorption is made in installment by introducing reservation policy in the manner as sought to be done in impugned scheme, many of the eligible petitioners may not get ultimate benefit of the order because of attainment of the age of superannuation even before the term of absorption ends. That apart, conjoined reading of the directions of the learned tribunal and the directions of the earlier division bench makes it clear that on absorption of the petitioners, they will get the entire benefits with effect from the date of their. Now, this is that apart, conjoined reading of the directions of the learned tribunal and the directions of the division bench makes it clear that on absorption of the petitioners, they will get the entire benefits with effect from the date of their respective appointments. Meaning thereby the effect of such absorption will relate back to the date of the respective appointments. This aspect has not been taken into consideration by the administration by framing the scheme. So, my lords, this is a case where admittedly there was a scheme. And my lords, in the implementation of the scheme of regularization, the court has said that you give them the benefits from the date of their appointment. So, my lord, this is not at all applicable to the present case because today there is no scheme. That is exactly what I was submitting. Once the scheme is published, and then, my lords, they need certain other benefits are required to be given for them. It is possible for them to.
Not only that, the scheme, as I find from, is confined to the home guards only.
Yes, my lord. Parity cannot be, my lords, on the basis of an order passed pursuant to another court order.
Yes, Mr. Kumar.
No, my lord, he has not read the entire.
No, I'll read that.
No scheme was.
Before parting with, we make it clear we do not find any unreasonableness in the eligibility criteria which has been introduced to said scheme for absorption of the petitioner. Mr. Ray, however, tried to impress upon us that sufficient number of vacant posts are not readily available where the petitioners can be absorbed at a time. As such, the official respondents may be permitted to frame a suitable scheme for absorbing the petitioners in installment in the existing available vacant posts, as well as in the posts which will fall vacant subsequently by maintaining their seniority with reference to respective date of their engagements in the voluntary service. Mr. Ray further contended that all the petitioners required to be absorbed at a time in the existing vacant posts in various departments of the administration, the normal process of recruitment will be suspended totally, which may cause prejudice to various eligible candidates belonging to the general as well as reserved categories. He cannot accept such suggestion of Mr. Ray, as they have already observed that such proposal is against the spirit of the judgment of earlier division bench. As such, the official respondents are required to find out the ways and means as to how eligible petitioners and other similarly placed persons can be absorbed on regularization of the service at a time. If, however, it is found that all persons cannot be accommodated at a time in different establishments of the administration, then concerned respondent is required to create supernumerary posts so that the eligible persons can be accommodated in suitable posts at a time, subject to satisfaction of eligibility criteria. Such posts, however, may be abolished on retirement and or termination of service of the petitioner. The writ petition thus stands allowed with, however, without any order as to costs. So, my lord, this judgment doesn't lay down any law that the supernumerary posts, upon their creation, the benefits are to be given from the date of appointment. It was, my learned senior has shown a departmental order where the benefits have been given, but it is pursuant to this division bench order where the direction was for regularization. So, my lord, there, under the supernumerary post, the benefit of regularization in terms of the division bench's order has been given to them. Now, my lords, my submission is a legal submission, my lords. My lords, may now I'll just show, my lords, specifically before I come to the larger issue. My lords, may first see specifically, my lords, how the Supreme Court has recently treated this question of supernumerary posts. The first judgment, my lords, I'm relying upon. This is a judgment of state of Gujarat versus R.J. Pathan. Now, my lords, may straight away come. This is a case where, my lords, there was a mandamus given by the writ court, by the division bench rather, whereby, my lords, may see on the first page, there was a direction for creating supernumerary posts. Against that order of the direction for creation of supernumerary posts, my lords, the SLP was preferred, and it was converted into a civil appeal, not a mere dismissal order. My lords, straight away, my lords, come to para 8, which is at page 9. Now, so far as reliance upon placed upon decision of this court in the case of Uma Devi and subsequent decision of this court in the case of Narendra Singh Tiwari, relied upon by learned counsel appearing on behalf of the respondents, is concerned, none of the aforesaid decisions shall be applicable to the facts of the case on hand. The purpose and intent of decision in Uma Devi was, 1, to prevent irregular or illegal appointments in future, 2, to confer a benefit on those who have been irregularly appointed in the past and who have continued for a very long time. The decision of Uma Devi may be applicable in a case where appointments were irregular on the sanctioned post in regular. The same does not apply to temporary appointments made in a project or program. Even in the case of Narendra Kumar Tiwari, also it was case of irregularly appointed employees. Even otherwise, in view of facts and circumstances, the said decision shall not be applicable. The case before this court was with respect to employees working with the state of Jharkhand, which was created only on November 2000, and therefore it was contended on behalf of the irregularly appointed employees that no one could have completed 10 years, etc. from the cutoff date, which was cutoff date fixed under the relevant rules of the state of Jharkhand. And therefore, they said, give us supernumerary posts. Now, my lords may see what the court says at paragraph 10. From the impugned order passed by the division bench, so paragraph 1, then 8, and then 10. From the impugned order passed by the division bench of the High Court, it appears that High Court has observed here and above that in the peculiar facts and circumstances of the case, it was directed that order of absorption and regularization, and if necessary, by creating supernumerary posts. This is exactly what was done by the division bench in that case, in the Home Guards case. It will not be treated as a precedent in other cases. Even such a direction could not have been passed by the division bench, as there were no peculiar facts and circumstances warranted such observation. No such order of absorption and or regularization, even if required for creating supernumerary posts and not to treat the same as precedent, could have been passed in exercise of powers under Article 226 of the Constitution. So this is the general view, my lords, of the Supreme Court. Now, my lords, we take another judgment, which is very relevant, my lords, because here we are dealing with the issue of giving the service benefits from the date of appointment and the consequences of giving the service benefit from the date of appointment. Now, my lords, we say take this judgment at 2008, my lord, judgment of Justice Ravindran, because I'm just passing it. My lords may see paragraphs 8, 9, and 10 of this judgment. Para 8, the orders dated 9th April 1987 and 29th October 1991 make it clear that this court did not intend any regularized doctor to steal a march over the regularly appointed doctor, either individually or as a group. To ensure that the seniority and promotional aspects of regularly recruited doctors were not affected, this court created a separate seniority list in respect of regularized doctors and clarified that their promotions will only be in supernumerary posts to be created. Supernumerary posts are non-cadre permanent posts. They are created to accommodate the lien of officers who are entitled to hold a lien against regular permanent posts. Being ex-cadre posts, no specific duties are attached to them, and the officers concerned usually perform duties in some vacant or permanent posts. Para 9. If all the ad hoc doctors were to be regularized with effect from the date of their initial appointment, this is what they are seeking here, with seniority also from the date of initial appointment, there will be no difference between regular recruitment and regularization of ad hoc appointments, thereby defeating the very purpose of systematic regular recruitment through UPSC. Ad hoc or stopgap appointees are not normally regularized and given seniority from the date of their initial appointment. They were usually given regularization and seniority only after a certain period of service, which used to vary from 1 year to 10 years or even more. When this court directed on 9/4/1987 that regularized doctors will have seniority from the date of the initial appointment, it was only a direction intended to regulate the seniority inter se the regularized doctors, as the court found that among the ad hoc appointees, regularization was not being effected in accordance with seniority, and some who were subsequently appointed were being regularized earlier, and some who were earlier appointed were being regularized later. It was not intended to affect the seniority of regularly appointed doctors. The regularized doctors cannot occupy the posts meant for regular doctors, either at entry level or at higher promotional levels. When the clarificatory order dated 29/10/1991 was passed, this court took care to direct that promotions of regularized doctors will only be in supernumerary posts. This court also directed that promotion of any regularized doctors will be on par with the promotion of the regularly recruited doctors who is immediately junior to the regularized doctor. This meant that if one regularly appointed doctor was promoted, one regularized doctor, that is the senior most from these regularized doctors whose date of initial appointment was earlier to that of the said promoted regularly appointed doctor, was to be promoted by creating a supernumerary post. The above is also clear from a wording of 3B of the directions dated 29/10/1991, which use the term on par and uses singular and not plural when referring to the regularized doctor to be promoted. The clarificatory order dated 29/10/1991 did not mean that if one regularly appointed doctor was promoted, all regularized doctors appointed earlier to his appointment should be promoted to a higher post by creating that many number of supernumerary posts. Such an interpretation will lead to absurd results and give undue advantage in promotions to regularized doctors who are outside the cadre. To clarify the interpretation, we are given below, and an illustration. Illustration on 1st 2008, there were 50 regularly appointed chief medical officers and 25 regularized chief medical officers. One regularly appointed CMO, whose date of appointment is 1/1/1990, is promoted to senior administrative grade. Out of 25 regularized CMOs, 10 were appointed prior to 1/1/1990. The clarificatory directions dated 29/10/1991 do not require all 10 regularized CMOs appointed prior to 1/1/1990 to be promoted to senior administrative grade by creating 10 supernumerary posts. All that it requires is that when one regularly appointed doctor is holding the post of CMO is promoted, one regularized doctor holding the post of supernumerary post of CMO, who is senior most from among the regularized doctors who were appointed prior to 1/1/1990 will have to be promoted to a supernumerary post of senior administrative grade. So the intention of the Supreme Court, even in this judgment, is to make it very clear that when you are appointed to a supernumerary post, your service benefits cannot come in the way of regularly appointed persons. And even in the earlier judgment, my lords, exactly, my lords, because they were not meeting the criteria and regularization, the Gujarat High Court division bench had directed create supernumerary posts. The Supreme Court said you cannot do this. Because, and now, my lords, we see generally, my lords, generally, since much reliance is being placed on the judgment of the division bench in the earlier round, even otherwise, my lords, now, my lords, will the latest view, my lords, of the Supreme Court, my lords, on the question of, today we are not faced with the situation of regularization, but my lords, I just wanted to place this one judgment, my lords. This is the Union of India versus Ilmo Devi, my lords. My lords may see what is the scope, my lords, of interference when it, or rather direction for mandamus, my lords, when it comes to regularization. Now, my lords may just see paras 21, 25, and 26. 21, at the outset, it is required to be noted the respondents, original applicants, were working as contingent part-time sweepers in a post office at Chandigarh. It is not in dispute and cannot be disputed that there are no sanctioned posts of Safaiwalas in the post office in which the respondents were working. There is no documentary evidence on record to establish and prove that the respondents were working continuously. Even otherwise, as observed above, they were working as contingent part-time sweepers. Even it is not the case on behalf of the respondent, the appointment was done after following due procedure of selection, and to that extent, it cannot be said that appointments were irregular. As such, in the absence of any sanctioned post in post office in which the respondents were working, there was no question of appointing the respondents after following due procedure. In light of the above directions, the High Court in its impugned judgment order are required to be considered. Now, my lords may see para 25, which is on the next, which is at page, my lords, page 7. Para 25, the observations made in para 9 are on surmises and conjectures. Even the observations made that they work continuously and for the whole day are without basis and no supporting evidence. In any case, the fact remains the respondents served as part-time employees and were contingent paid staff. As observed above, there was no sanctioned post in post office in which the respondents were working. Therefore, directions passed by the High Court in impugned judgment order not permissible. The High Court cannot, in exercise of power under Article 226, issue a mandamus to direct the department to sanction and create posts. The High Court, in exercise of powers under Article 226, also cannot direct the government and or department to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation and or sanction of the post is also sole prerogative of the government, and the High Court, in exercise of power under Article 226, cannot issue mandamus and or direct to create and sanction the posts. Para 26. Even the regularization policy to regularize the services of the employees working on temporary status and or casual laborers is a policy decision, and in judicial review, court cannot issue mandamus and or issue mandatory directions to do so. In the case of R.S. Hon'ble, it is observed and held by this court that the status of permanency cannot be granted when there is no post. It is further observed that mere continuance every year of seasonal work during the period when work was available does not constitute a permanent status unless there exists a post and regularization is done. So, my lords, my submission is that it is not permissible for the petitioners in the absence of a policy of regularization. Where there is a policy of regularization, the scheme is not followed properly, it is followed discriminatorily, it's a separate issue. Today, there is no policy of regularization. They have been appointed to supernumerary posts, which does not change their status from being casual workers. It is just the benefit of the post that is given. What they are now seeking to get the benefits from the date of initial appointment is basically to get the status of a regular employee, which, my lords, they cannot do for several reasons. They cannot invite the court to pass such a mandamus, my lords, because today the scheme of regularization is not in place yet. It's not like they are exercising their rights under the scheme and the court is called upon to interpret. Without a scheme, my lords, they are inviting the court to pass a mandamus that they should be given the benefits from the date of initial appointment. My lords, that in the case that they have cited was a situation where there was a specific direction of the division bench to regularize them. And since there were no posts, the division bench said regularize them to supernumerary posts. I am not today in challenge against that order, but my lords, today I have shown 2-3 Supreme Court judgments, my lords, that, but even assuming in that particular case, in the peculiar facts, the court passed such a direction, the administration complied with that order. Today, there is no direction for their regularization. They have only been appointed to supernumerary posts.
I was on that. Yes, there's a direction for supernumerary posts.
There is no direction for
For
regularization.
regularization.
There is no
That's
direction for
different.
regularization, my lord. So today, my lords, they are actually, my lords, they are treating they are treating the supernumerary post like a regular appointment, and they are trying to say that we have like a person who is given an ad hoc employee who is given regular appointment often comes to the court to say that no, give me the benefits from the date of initial, take the ad hoc service into account. But fact of the matter is they are not regular employees. They are only appointed to supernumerary posts. In that particular case that they're relying upon, there was a direction for regularization. Irrespective of my contention that such a direction couldn't have been issued, but be that as it may, my lords, the division bench issued a direction for regularization, and to comply with that direction, the division bench said that honorable division bench said that you create supernumerary posts. So therefore, they were regularized to supernumerary posts. Here, there is no direction for regularization, and in the change scenario of the latest judgments, my lords, the direction for regularization, with the greatest of respect, my lords, it is not available for the petitioners to invite the court to pass a direction for regularization.
That's all.
Yes, ma'am. I will come back tomorrow.
You'll come back.
Yes.
Please consider these decisions.
Madam, this decision has got nothing to do with my case, madam. These decisions. I have got.
Prima facie appears that you are relying on that
Judgment.
seeking parity
Yes,
on the
yes,
judgment.
yes,
But that confines to only the home guard category.
my lord, my lord.
Under
But they are under the
a
administration.
scheme,
Yes, my lord,
under a specified scheme.
my lord,
So here for you, there is no scheme as
my lord,
such.
my lord.
Right?
I will raise that.
Consider these aspects
Yes,
and come.
yes,
My lords, if I need to give a rejoinder, my lords, then I will take time on Wednesday.
my lord.
For learned counsels for the parties. Paragraph, let the matter appear under the same heading. You want to come back on Monday,
Monday, my lord.
16.
Monday.
Lot of newspapers, be careful. Please. This is also, this is the past over. Past over matters are ready.
Yes, my lord. Yes. My lords, I had to come back with instructions, my lord, on that. I should have.
Which matter?
That Neha builder, my lord.
Item number?
Three.
Three.
Item number 3. Item number. Yes, my lords, item number 3. So, my lords, my lords, your lordship's indication to the administration was that what has been done to that fund of 1.82 crores.
Yes, yes.
So, my lords, we have received this written instructions, which I'll just pass on, my lords. The instructions are that so far as the first installment amount of 1.82 crores is concerned, it was released on 26 March 2020, and payment was made to works that were completed on 26 March 2020. Now, this was released to various contractors who had submitted completion certificates. So far as the present petition is concerned, as on 26 March 2020, they had not completed the work. So, my lords, their claim came subsequently. And by then, my lords, the fund of the first installment was exhausted, and we have requested written to the ministry to release the second installment so as to make payments to them. This is the position. I'm just handing over, my lord. This is the report which has been
So
received.
you received a copy?
My lord, I've
Given on
given a
WhatsApp.
copy only of 2 pages.
So I
do
can
not have
give
the
my,
annexures.
I don't have just now received, so I can give connection this answer. My lords,
Annexures need to be given to
I
you.
have to give the annexures.
So will you go through this and come back?
I can do so if my learned friend serves me with the annexures.
Will
Yes,
you
yes,
give
I'm-
him here and now?
I
the
don't have,
copies?
or this is the, or my lords, I can just.
Or you can, I'll just
I
take it
can-
not today, you can come back with this after serving a copy on Monday.
Yes.
I have seen, Mr. Chakraborty shared it with me, so I've seen it. Prima facie, there is one basic discrepancy, one basic inconsistency. If your lordship sees page 8 of their affidavit, the affidavit in opposition, I pointed this out the other day. This is just repetition. The money that was transferred by the administration at page 8 was transferred to Mayabandar 182. The
Yes,
second paragraph is that the same is to be utilized for the purpose as mentioned in the annexure. Now, the annexure indicates at page 9. At page 9, as I
Yes.
pointed out that day, 1, 3, and 5.
yes, yes.
So these are my projects. I fail to understand how they are relying on a document today, which shows that 182 was disbursed to other contractors for other work.
And not only that, this amount was specifically for Mayabandar.
It was for
Page
Mayabandar,
It's your document.
specifically for Mayabandar, and specifically for the projects as mentioned.
No, my amount has been released from Mayabandar only, but to other contractors.
No, you can't use it. That this is the whole point of a deposit.
Civil dispute.
No, it is not a civil dispute.
Where are the other contractors in Mayabandar? I do not, they're all from different places.
Now, if your lordship sees the document given
One is
today,
Rangat, it's Karnikobar.
it has various other places.
An affidavit otherwise.
No, this is now trying to delay the matter. The
How much
situation is
time
very
did you
simple.
take to clear the amount? That's the
Manos,
primary
That
question.
is why Manos had placed the other order, Manos, the ministry has made a party, Manos, it can.
Not necessary, it's between you interesting. Court will not get into it.
We are following the, we are following up with the.
Where are the documents showing that you are following up with the ministry?
No, that still doesn't explain. If money is
show the
allocated by the government to use it for anything else, means that the money is being diverted for other purposes.
It's paid to other contractors who had.
Please
completed
read
the
your
work.
own order at page 8. The amount sanctioned is subject to the condition the same shall be utilized for the purpose mentioned in the
It
annexure.
has been utilized for the.
For the
of other
purpose,
contractors who
no, that
completed
cannot
the
be
work.
done. That is,
I'm not saying whether
that
it's
is-
wrong or right, but there is no, it is.
that
not
is
something
why I'm
that's
using the
written.
word diverted.
It's not diverted. It's not like somebody has
It's been used for other purposes. DHOS this.
Rehost your own order.
Contractors who have performed, completed their work. So my lords that, but in any event, my lords, they completed their work later. So my lords, it is only again works completed then.
But this order says it should be for the purpose mentioned in the annexure.
There may
My
have,
lord.
no, therefore, my lords, if the fact is that they did not complete the work and the contractors who completed the work was given to them, my lords, whether that is a mistake, my lords,
How? Yes,
that
it
my
appears
lords,
to be a mistake. Because this order is very clear and specific.
my lords, we are following.
182.18 for these 9 works in the annexure,
My lords,
out of which 3 are of the petitioner.
my lords,
So that amount should have been kept reserved for him.
And as we see the letter at page 30 of the affidavit in opposition on 21st September 2023, my lords, we have written to the Ministry of Minority Affairs. And we have specifically requested them to release my lords.
The problem is the ministry has written back saying there are discrepancies. The money we sent you for this purpose has been used for some other purpose.
We are following.
So because there is a discrepancy, now the ministry has refused to release any further funds. That is also part of their records.
Separate.
Everything cannot be separate. If your lordship sees the letter that has come from the ministry,
This is the latest letter.
page 20, it specifically says that till the discrepancies are removed, there will be no further funds being released.
That's a
Page
prior-
20 and 21.
Prior in time.
Money allocated to me, you spend elsewhere.
Time is not really a factor here. The orders very clearly says that this is for these works. The same shall be utilized for the purpose as mentioned in the annexure. So how could this have been given to others?
And now your
For
lordship will
completion
see
of other
page
work.
20 and 21. This is the stand of the ministry which they are relying on. Page 20.5. The mismatch in the amount and the projects is exactly what is now apparent. The ministry has said you've used the money for some things. And now kindly see page 21. Page 21, last paragraph. Further funds under this scheme can be released only after reconciliation of all the data. The administration has created a situation. The ministry is saying there's a discrepancy. We gave you money for A, you used it for B. Now we won't release further funds. I am stuck.
Well, then I was what they have. Inviting the court, my lord, they are seeking a kind of a money decree, my lord. Then my lord.
Certainly not. These are administrative actions, executive actions. You cannot act divorce the laws and your own rules.
You cannot hold back the money of the contractors, isn't it?
I appreciate.
Under any circumstance.
Laws may then
Let there be a direction within 1 month, clear. Otherwise, come back in contempt.
reasonable time to be drafted. Because 1 month, my lord, this is. And that may grant us some more time.
Whether this man will survive another month is a question I ask myself. You have had time since 2020, my lord, kindly consider 3 years have passed.
Let's see in that.
3 months, my lord.
Third learned counsels for the parties. The petitioner, being a class 3 government contractor, enlisted with the Andaman Public Works Department, entered into a contract agreement
But 4 contracts.
for
Paragraph 4 and paragraph 6. 4 gives the details of the agreements and the conference.
was awarded, not entered into, was awarded 4 contract agreements by the authority for construction of Anganwadi building in different places. Stop. Upon completion of the work, comma, certificate of completion was issued in favor of the petitioner on 10th June 2021, comma, 11th April 2021, 12th April 2021, and 16th August 2021 respectively. The petitioner submitted bills for the said work before the authority on
Paragraph 6, 13th October 21 for 2 of them, October 21 for the 3rd, and 20th January 22 for the 4th.
on 13th October 2021. In October 2021 and January 2022.
Right.
Which have not been cleared till date. Stop. Paragraph, learned counsel for the petitioner takes this court to annexure R1 to the affidavit in opposition used by the respondents, which demonstrates that rupees 182.18 lakhs was sanctioned and transferred to the account of the Mayabandar administration.
My lord, executive engineer, North Andaman Construction Division, Mayabandar, account number so and so at page 8.
Page
8. 8 of the affidavit in opposition.
this part is not clear here.
To
Yes,
the
transferred.
executive
to the executive engineer, comma,
NACD Mayaband.
NACD, comma, Mayabandar. Subject to condition that the same would be utilized for the purpose as mentioned in the annexure appended thereto. Stop. The annexure includes the projects of the petitioner. Stop. Despite such order, comma, not a farthing has been paid to the petitioner till date. The petitioner seeks a direction upon the authority to clear the entire bills of the petitioner at the earliest paragraph. It is submitted on behalf of the respondents that the amount received by the authority as first installment was paid to the contractors who completed their work prior to that of the petitioner. No further fund is available with the authority at present, and the authority has taken up the issue with the ministry for placement of fund. Paragraph. It is relevant to it is pertinent to record that in reply to release of balance amount, there are the communications.
Page 20 is the communication from the ministry.
Release of balance
Communication from
amount.
The administration is there at page 10.
Yes,
The ministry's reply is at 20.
by the ministry, comma.
Point 5 and the next page, point 8.
It is stated, with a letter issued on 17th March 2023, that the utilization certificates received by the ministry could not be reconciled due to mismatch in the amount and the projects. The letter says that further funds can be released only after reconciliation of data and geotagging of the PMJVK assets. Paragraph.
Well, we have taken it up late. After that, minus we see the letter at page 30 of the affidavit in opposition, 21st September 2020. August 2020.
How have you responded to the earlier letter?
23rd August, see there are two letters.
It's actually at page 27. Annexure R5, 31st August 2023. Social welfare has
37. There is no 37 in the opposition.
27. The social welfare department has written back to the ministry without the reconciliation being done.
Let us first see page number 25, annexure R4. 23rd August 2023.
You've asked for release, but how have you reconciled?
So we have.
Did you meet the requirement of the ministry?
Minus we have then.
No, that has not been done.
We have expressed further letters and minus we see the letter at page 30.
Each of the letters says we've spent this much, we need more. We've spent this much, we need.
Minus we see the letter at page 31.
Yes.
Because here we are saying that we have, in this regard, it is to inform the ministry has released first installment The different construction divisions have furnished the revised utilization certificate and was forwarded to ministry with a mention letter. Further, this department with a letter number 31st August requested to release an amount of such and such for payment towards salary of block level facility payment of pending dues against national projects. In this connection, the mentioned the matter has been adversely reported. 2 writ petitions have been filed. Therefore, directions may be issued. So we are taking up the matter, minus. We are taking steps. That's all that I'm saying. We have addressed further letters dated 23rd August 2023, 31st August 2023, and 21st September 2020.
True, but the reconciliation has not
No,
happened.
that we are taking it up at our level.
Paragraph Learned Counsel for the respondent submits that communications are being made with the ministry to reconcile the issue and get clearance of funds. Paragraph. Shall I record your assurance that it will be cleared?
Minus be direct. Minus.
His assurance will put him in difficulty, madam. Not his
It will be
assurance.
difficult, yes.
We are on different sides, but he will be in trouble.
I know, cannot be. Paragraph, be that as it may, comma. This court is inclined to hold that since the amount due to the petitioner is pending since long, comma, the concerned authority, comma, being the, who is to clear?
Hello, the executive engineer, NACD Mayabandar, is the one who has affirmed the affidavit. But
So he's not a party.
he's not a party. The actual party will be the chief engineer of the APWD.
So let the 6th respondent be directed. Yes?
Yes.
The 6th respondent be the chief engineer, comma, Andaman Public Works Department, comma, being the 6th respondent herein, comma, be directed to directed to take necessary steps.
Chief engineer may not say that the Andaman Public Works Department, because that is the party concerned. So that's only the designation of the person heading the department, but the department is the Andaman Public Works Department.
Whom do we hold in contempt after that?
No, that they'll obviously then they'll decide
becomes
that is
vague.
their prerogative.
No, no.
No, it
Cannot
has
be.
to be a
Cannot be.
specific
It has to be
authority
a
when a
person.
mandamus is being issued.
Let it be the chief engineer. Be directed to take all necessary steps for disbursal of the dues of the petitioner within 3 months.
No,
3 months will be a long time.
no, Manus. No, Manus, I have been instructed to request for 4 months, Manus. 3 months is recent.
4 months is out of the question. Why don't we keep it to 2 months?
No, Manus, there'll be a.
I don't want to haggle with the court, my lord, your lordship. It fell from your lordship 1 month. Here, if they have made so many communications to the ministry and they are pursuing them.
There are holidays in
10
between, my lord.
weeks. 10 weeks.
I'm good.
Within 10 weeks from the date of communication of this order.
There are holidays in between also.
10 weeks.
Manus.
So that's 2.5 months.
Right.
Disposed of those 4 lines.
My lord will kindly record 2 things. The report of today is placed on record.
The report is not yet placed on
Right.
record.
Manus, so take it on record.
And that a copy be served. I have full faith in Mr. Chakraborty, he'll give it to me.
A report submitted on behalf of the respondents is taken on record. Paragraph, the respondents are directed to serve a copy of the report.
WhatsApp also is fine, just
Uh,
exchange it.
The respondents are directed to make over a copy of the report to learned counsel for the petitioner in course of this day.
Man,
The 2 other passed over matters?
My lord.
Yes. Let me take up the passed over matters.
I got the instruction final. Let the order be passed. Disposing of my representations.
I'm appearing for respondent number 3 and 7.
It is contended on behalf of the petitioner that being the lowest bidder in the e-tender floated by the respondents, comma,
Respondent number 7.
the petitioner executed the work covered by the tender and upon completion of the same, comma, submitted bills in the year 2019. Stop. The said bills are yet to be cleared. Stop. Several representations submitted by the petitioner before the authority within bracket annexure P6 to
P9,
P9.
legal notice last. P8 is the notice. And P9 is the legal notice.
P9 to the writ petition within bracket, bracket closed. Fell on deaf ears, EARS. The petitioner seeks a direction upon the authority to consider the representations at the earliest and cleared the bills, cleared the dues of the petitioner. Paragraph
On
learned,
respondent number 3, ma'am.
paragraph learned counsel for the respondents submits that the deputy commissioner will deal with it.
He will release.
The third respondent be directed to consider the representations in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representations submitted by the petitioner within bracket annexures P1 to P9, no, P6 to P9. Bracket closed.
P5 to
Within-
P9.
P5 to P9,
Yes,
5 is also a representation.
representation. That was on 24th of January.
No, 5 is not the representation.
136, my lord.
P6 is the representation. 6 to
Right.
9. Within 4 weeks from the date of communication of this order,
One more time.
My,
It's a huge amount of money, minus.
6 weeks.
8 weeks.
Within 8 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner. You are the private respondent.
No, my lord, respond number.
Respondent number
Respond number 3 and
3 and
3,
7.
comma, if required, comma, in accordance with law. Disposed of these 4 lines.
Oblige, lord.
Same order in.
Same order.
5.
4 and 5, same one.
Item 6, PA 941 to 943.
Item 6
No.
is passed over.
Yes, sir.
Yes.
I'm there for the motion. The service, because in the last occasion, my lord can recollect, 2 private respondents were there. One has been served, the other has not been.
Yes.
Even that has been done, I filed it. He has refused, my lordship. There's an inducement. I filed along with the affidavit.
5th respondent. Om Prakash, served, refused is served. That's service.
Not the order of the Tahsildar,
Administration, your opinion.
I am appearing.
but the order of the Tahsildar at page 22 is under challenge. And actually,
I have challenged the point of maintainability that it is an appealable order. Order passed by the
please.
Tahsildar is appealable before the sub-divisional officer.
Please show me the relevant rules. You were heard by the Tahsildar?
No,
Lord,
Lord, certain
Regular
reports,
section
alleged
22,
reports
28.
being the adverse material were used against me to come to such finding. The reports were not supplied. Lord, it's purely violation. Lord, so any
That's
adverse.
where I'm on that.
My lord,
please.
Regulation 28, my lord. Page number 7. Appeal revision and review. Save as otherwise provided in this regulation. An appeal shall lie from every original order passed by this regulation or rules made thereunder. If such order is passed by any revenue officer subordinate to subdivision officer, whether or not the officer passing the order is invested with the power of the deputy commissioner to the subdivision officer. He is subordinate to the subdivision officer, so this clause will be attracted, my lord.
Was the petitioner heard before the order was passed?
My lord,
Otherwise, it's violation of natural justice. The court can intervene. Is
it was
it?
heard, my lord.
Where is the document?
That
The petitioner is
paragraph-
A. Mohan.
paragraph 4. The respondent present before this court did not challenge the period of disposal,
Paragraph 4.
my lord, of the order. The matter was heard on 7/9/2023 and found that temporary structure building built by Mohan is standing on survey numbers situated at Janglighat, which stands recorded in favor of Manorama Devi and Om Prakash. The respondents present before this court did not challenge the period of disposition within 2 years.
Yes, it
No,
was in your
No,
presence.
no, mainly on two grounds. First, my lord, second paragraph may kindly be seen, lordship. Page 22. Not an
Yes.
adverse material were collected against me to come to this finding.
So that's what merits.
No. Supreme Court says it theory of non-disclosures comes in. If any adverse decision is taken on based on adverse material, I'm entitled to get the material beforehand, before the order is passed. Otherwise, that would amount to audio order pattern non-compliance. This first point I've raised it. Any adverse material, it's a law, lordship. Administrative authority taking any decision, adverse decision, based on certain adverse material, have to be disclosed to me. If it is voluminous, I have a right to inspection. Even that was not done. I've taken a specific stand in the writ application. It is only when the writ petition was filed, I've come to know that the report has been relied heavily. Is first point. Secondly, my lord, third line says it was heard. Whether I was given a notice, whether I was present, nowhere it says. No, it's a tactfully the orders are being made. No, secondly,
A revenue report has been relied upon. It's not a private
the
document.
report, those judgments, my lord, knows report is an adverse because I'm an adjacent plot holder. It's not an I'm an encroacher. I'm an adjacent. My wife possesses a land adjacent to this land. We have raised a construction. The Tahsildar called for certain reports before taking any decision. My lord, the reports ought to have been given to me beforehand because I was not being heard. When this order was served to me, what I have did, my lord, kindly turns to page
Did you
24.
raise this objection before the court, before the hearing here?
Yes, I have
To
raised
the
it.
Tahsildar?
No, I am not given a notice. This was not.
It was heard in
No,
your
no,
presence,
no,
sir.
let them give this record. This RC case, everything would be clear. If I am put in notice, I was heard, my signature would have been obtained in the order sheet. This RC case file will call for membership on Monday, everything will be clear. This is one. Secondly, my lord, when I was served with this notice, not kindly come to page 24. I have requested the Tahsildar because under regulation 34, once an eviction order is passed, the Tahsildar has to stay his hand till I take appropriate law in my action for challenging the order. Not kindly see the regulation 35. This was not considered. It was addressed to Tahsildar at the top, not page 24. I said,
This is again on merits.
no, I'm on
This
this.
is not technical.
No, true. Now, let them show any document that I was heard before this decision could be taken. In a revenue proceeding, lordship, a notice needs to be given.
The order itself records
Not,
that it was in your presence.
no, it says matter was heard, my lord, not in my presence. It says third paragraph, first line. And whereas the matter was heard on 7/9/2023, the private respondents might have heard, my lord, but
After that,
and found that the temporary structure built by Mohan is standing. It was a finding, my
the
lord.
respondent present before this court did not challenge the period
It
of
was a
disposition.
finding that M.A. Mohan, the writ petition is found in occupation. This was a finding based on
And
the
even
complete.
on in the next page, after due submission by the petitioner respondent, and so you were present, sir.
No,
So this is an
petition,
appealable order.
the proceeding is Manorama, private respondent, page 22.
Yes.
I'm not the petitioner. Petitioner was Manorama Barwa, private respondent.
Respond, you were the
This is a
respondent.
wrong, not let the record be called once more. So
How
Monday,
can an order be wrong? It's recorded that you were there.
no, it's don't says clearly that I've been given a notice. I've been given a not
Yes,
regulation.
can you come back with the documents
RC file number 16.
showing that notice was served upon this,
Yeah, Lord.
this petitioner?
Yes, my lord.
Yes,
Yes, ma'am.
so that will solve the issue.
Yes, ma'am.
When can you come back? Tuesday?
Tuesday, my lord.
Yes,
My lord. I sent.
the petitioner assails the order passed by the Tehsildar Port Blair on it's legible. What is the date of the order? 8th July.
This one. It's 8 September 2023.
23, 8
Yes, ma'am.
September 2023,
Yes.
primarily on the ground that no notice was served upon him prior to passing the order, and the order was passed behind his back. Stop. Paragraph, learned counsel for the respondents seeks to produce documents to show that notice of the hearing was served upon the petitioner and the petitioner was present at the time of hearing. Paragraph, let the matter appear under the same heading on 17th.
My lord. Oblige, my lord.
Item 8. WPA 968 of
The private respondent has not been served.
Not served.
Authorities have been served,
I
but I've just simply dispatched the copy of the.
correspond number 1213.
Next circuit,
Let it only on Thursday.
Thursday.
If I could not serve, no, I'll seek for next.
Since service upon the private respondent is not complete, comma, let the matter stand over till 19th.
Oblige, my lord.
Item 11. WPA 9 of 28.
My lord, I am appearing for the petition.
Yes,
My lord, here, the petitioner was initially engaged after a selection process on ad hoc basis. Subsequently, my lord, the petitioner was given regular appointment from the date of initial appointment. All along, the petitioner was discharging the duties of accountant under the municipal council. It is an autonomous body. Now, my lord, subsequently, the municipal authority adopted a resolution. My lord knows that in an autonomous body, it is governed by a regulation, and the resolution is the ultimate decision taken by the authority. Municipal authority has taken a resolution whereby they decided to appoint incumbents or promote the incumbents to the post of accountant on ad hoc basis initially. Now, my lord, on the basis of the said resolution, the resolution in terms of the regulation was communicated to the Andaman Nicobar administration. Subsequently, process were initiated, and I was appointed to the post of promoted to the post of accountant under the Port Blair Municipal Authority. My lord, after my such promotion to the said post, my lord, I was discharging the duties regularly for years together, on and from 2011 onwards, my lord, by the impugned order. If my lords come to impugned order dated 29 December 2017 first, my lord, and thereafter I will place the resolution and all.
at page
At page 47, last page of the writ petition, my lord.
47.
47, my lord, P14,
Yes,
my lord. I'm just reading the order, my lord. It is 29 December 2017.
this is
It's
impugned.
impugned, my lord. It says whereby Sri Sundar Rao, computer assistant A, was given ad hoc promotion to the post of accountant in PBMC, wide order number so and so dated 10th October 2011, my lord. And whereas the said ad hoc appointment was extended from time to time by different orders in pursuant to different resolution of the council. And whereas the recruitment rule for the post of accountant were in the official gazette dated 22nd of January 2011, classified it as a group B post and provides for direct recruitment only as the method of recruitment. And whereas as per rule 5(1) of the Andaman Nicobar Municipal Service Rule classification so and so, all appointment to group B post in the municipal service shall be made by the municipal council in accordance with the notified recruitment rule, and each such appointment shall be subject to the approval of the administrator. And whereas the approval of the administrator was not obtained for the ad hoc promotion. Kindly have a note of this, my lord. And whereas the matter was examined by the Andaman Nicobar administration and the ad hoc promotion has been considered to be irregular by the administration. Now, my lord, the only question which my lord has to consider, that if an act of the autonomous body is considered to be an irregular act, whether the order or the action taken on the basis of such irregular act can be declared as nullus by the administration or not. Administration accrued such power or not. When it is irregular, it is not illegal, my lord. And whereas the municipal council in its last meeting held on so and so has decided not to exceed the ad hoc promotion further beyond dated so and so, now Sri Sundar Rao is hereby reverted to the substantive post of so and so. Now, my lord, my only question for which I have agitated this writ application, my lord, the issue is that they said that you have done this, but you have not taken the approval of the administrator, and this is irregular. So, my lord, I say if an act was done by an autonomous body and it is not illegal and irregular within the four corners of the regulation which is promulgated under Article 240, then in that case the order cannot be set aside. This is my submission, my lord, and I will demonstrate from the provisions of the regulation. First, my lord, I just place the appointment order and all first, and thereafter I will place the.
Yes.
My lord, first, my lord, I am just placing it. Page 24 is my initial appointment, my lord. That is not the subject matter, my lord, but I am just placing it, my lord. In the year 2000, I was engaged as data entry operator, my lord. Now, my lord, kindly come to the next page, my lord. It is 2004. Such ad hoc appointment was regularized by the Port Blair Municipal Council from the date of initial appointment, my lord.
25.
25, my lord. 26th of August 2004. It says, my lord, the Port Blair Municipal Council, by its unanimous resolution adopted in the meeting on 4th of February 2004, pleased to regularize the service of the following ad hoc Group C employees of the council that the date of appointment, promotion, so and so. Regularize their service, my lord. My name appears at serial number 14, my lord.
Yes.
Now, my lord, it is my case, my lord. All along, I was posted in the account section, all along. And to demonstrate that, my lord, from page number 26 onwards, my lord will find the documents up to page number 35 are the documents wherefrom it clearly established that all along I was working in the account section. I have been assigned with the duties and responsibility of the accountant, my lord. All along, my lord. My lord, please, I can read it over.
No, it's there.
My lord, up to page number 35. And even, my lord, yeah, I will just place one document, my lord, at page 34. My lord will find even the administrative officer made at page 34, my lord, made an application to the ANITCO, my lord, which is again an autonomous body, whereby it says that I am directed to forward herein an application of Sundar Rao, Accountant, Municipal Council, for the post of Assistant Manager, Account, ANITCO for further action. I have applied and they have sent it, my lord. Now, my lord, and next page is a certificate issued by the account officer who says that I am doing this all works in the account section. Now, my lord, I am not on that, my lord. I just want to establish that all along I was posted in the account section, discharging the duties and responsibilities of the accountant, my lord. Now, my lord, the subject matter of this writ petition, now, my lord, kindly come to page 36, is a resolution adopted by the Port Blair Municipal Council on 12th of May 2011, my lord. It says, my lord, at the outset, Srimati so-and-so chairperson welcomed the so-and-so councillor and so-and-so. The chairperson said that the special meeting of the council is conveyed to consider the draft recruitment rule in respect of Group C post of typist, clerk, so-and-so, so-and-so, and the recruitment rule in respect of Group B post of assistant engineer civil, assistant architect, wide administration letter dated so-and-so of Port Blair Municipal Council, and the draft, my lord, and the draft recruitment rule in respect of Group C post B and C post of senior accountant, financial officer accountant, commercial accountant, divisional accountant, revenue officer, assistant revenue officer, so and so, published in the Daily Telegram on 6th of May 2011, while Andaman and Nicobar administration notification dated 17th February 2011. Suggestion, objection, if any, on these rules have to be furnished to the Commissioner cum Secretary Port Blair within the period of 30 days of its publication in the Daily Telegram. Now, my lord, after this, my lord, kindly come to the relevant portion at page 38, serial number 5, 6, and 7, my lord. Accountant, commercial accountant, divisional accountant. It says the council observed that the scale of pay and grade pay for both the post of accountant, commercial accountant, and divisional accountant is identical, and there is no vast difference in the nature of duties. The council therefore resolved that the post of accountant and commercial accountant be clubbed with the divisional accountant, making the number of posts in respect of divisional accountant as 3. The council also resolved to amend point number 2, 11, and 12 in respect of the recruitment rule for divisional accountant as under, so as to provide promotional avenue to the service HGC and CGC of the council. Now, my lord, method of recruitment, my lord, that with regard to that clause 2, clause 11 of the recruitment schedule, my lord. Method of number of posts 3, method of recruitment. Now, my lord, actually administration says that it is direct recruitment post. Now, my lord, the council has decided that it would be by promotion, failing which by direct recruitment.
Yes.
And thereafter, schedule 12, my lord, they say from among the serving higher grade clerk and computer assistant. My lord, I am a computer assistant with minimum 10 years of regular service, possessing the education qualification, so and so, so and so. Now, my lord, last paragraph, it says the council authorized the secretary of the council to communicate the above resolution to the administration immediately as the date of submission and objection of this rule is going to be expired. Now, my lord, after this, my lord, at page 40, on 5th of July 2011, it says, my lord, the proceeding of the special meeting of council held on so and so at 11 a.m. was confirmed by the council in its meeting held on so and so is forwarded for information. Now, my lord, will find that copy was sent to the secretary, to lieutenant governor, commissioner cum secretary, deputy commissioner, all. And my lord, will find even the section is code. Section, if serial number 3, the deputy commissioner in terms of the section 197 of the Andaman Nicobar municipal regulation, my lord. Now, page 41, my lord, kindly come to page 41, is with regard to the resolution in respect of the post in subject matter, my lord. Last paragraph. The council noted the short age of technical and administrative staff and large number of vacancy. Therefore, the council unanimously resolved to fill up all the vacant posts under its establishment. Promotion post may be filled up on ad hoc basis. The council has to, on several occasions, pass resolution, stress that the chairman of the PBMC will head the DPC selection for Group C. The matter will be again taken up with the lieutenant, and therefore only departmental promotion post shall be filled up on ad hoc basis. Now, my lord, two things they have decided. They said that it ought to be promotion, and second, they decided since the posts are lying vacant, so at present we will fill it on ad hoc basis. Now, my lord, this is the resolution adopted by the authority which was sent to the authorities, the Andaman Nicobar administration. Now, my lord, after this, my lord, a circular was published at page 42, my lord, circulated, my lord. Got it, my lord?
Yes, yes.
My lord, a post of accountant and division are lying vacant, which is to be filled up as per the proposed recruitment rule. My lord, kindly have a note of this. A recruitment rule was published claim and objection by the administration. They immediately taken out a resolution saying that this is our proposal. And on the basis of such proposed recruitment rule, they decided to appoint on ad hoc basis, and therefore this circular was issued. And therefore it was written, lying vacant which are to be filled up as per the proposed recruitment rule. Post of accountant, education qualification so and so, and it says from this higher grade clerk and the computer assistant, my lord. Now, my lord, on the basis of this, it was circulated, my lord, and my lord, I was appointed at page 43, my lord. The chairman, Port Blair Municipal Council is pleased to promote Sundar Rao computer to the post of accountant under the council in the pay band of rupees so and so purely on ad hoc basis for a period of 6 months with immediate effect and on the following terms and condition. My lord, it was extended from time to time. It is reflected in the impugned order itself, my lord. It was extended. Now, my lord, only on the basis of irregularity, whether such order can be set aside. Now, my lord, kindly come to the Andaman Nicobar Municipal Regulation 1994, my lord.
We have it. Please come to page 44.
My lord.
It says that it is extended till legal opinion is received and decision taken, or until such date.
Page 44, my lord.
44.
43 is the initial appointment.
Yes, but
Yes.
the extension was subject to legal opinion.
My lord. Following post is extended till a legal opinion is arrived. Thereafter, now, my lord, if my lord sees subsequent extension, it is not there, my lord. Page 45, 46. I'm sorry, my lord.
45 is
No,
the-
no, I am sorry, my lord.
These are
My
the
lord.
extensions.
My lord, my lord.
So the
This
extension
was
subject to legal
my
opinion.
lord. It was up to 31st December 2017. That page 44, my lord. My lord, subject to legal opinion, but whether the legal opinion, whatever, because they might have taken the legal opinion and thereafter this order was passed, whether it is correct or not, my lord. This is with regard to last extension, my lord. My lord, 2011 I was appointed, and page 44, which my lord says, it is an order dated 22nd of August 2017, my lord.
Yes.
So from 2011 I am working continuously.
So there was a rider to your extension.
no,
That's
no.
what I'm saying.
No, at that junction it was not there. 2011, my lord, page 43 is the initial appointment. Page 43. There was no rider.
For a period of 6 months.
6 months. It was extended from time to time. And the document at page 44 is of 2017 August, my lord.
And the fourth clause also says it will not give a grant, confer
No,
any.
that is always there, my lord. That is always there.
Because after all, it's ad hoc.
Ad hoc. That is always there. My lord, that is always there, my lord. In any ad hoc appointment, it would be there. Now, my lord, what I am on, my lord, the ground on the basis of which the said promotion was set aside, I say that cannot be sustained, my lord. If my lord once come to page 47, last 2 paragraphs, last 3 paragraphs,
Approval not taken.
Approval not taken. This is one ground. Second ground, on the basis of that, it is an irregular promotion. This is the only issue my lord has to consider. And I will cite one judgment of, though it is not binding upon my lord, single bench judgment is there, wherein same issue was considered. There was also in irregularity. The court said nothing doing. It is only an irregular. Ultimately, it is an autonomous body. Now, my lord, I am placing rules, regulation 61, 61st, my lord. My lord.
60, yes.
My lord. It says no resolution of a municipality shall be modified or cancelled within 6 months after the passing thereof.
Within 6 months.
With, no, my lord. No resolution of a municipality shall be modified or cancelled within 6 months after the passing thereof, my lord. My lord. Thereafter, my lord, kindly come to clause 61, subclause 2, my lord.
Within 6 months, unless previous notice has been given, there are.
Yes, yes. Yeah, there are provisions, my lord. Yes.
So this is not really applicable.
No, they're really not applicable, but kindly come to 61(2).
Yes.
It says a copy of every resolution passed at any meeting of a municipality shall within 10 days from the date of the meeting be forwarded to the deputy commissioner. That, my lord, I have shown, my lord, it has been sent, my lord. And even in the said letter also it was mentioned that it was sent to the deputy commissioner. Now, my lord, thereafter, my lord, kindly come to 198.
Yes.
It says the administrator may by order in writing suspend or cancel any resolution passed or issue or license or permission granted or prohibit the doing of so and so such resolution, so and so, so and so, so and so. It is there. Provided that, last, my lord, the administrator shall, before taking action under this section on any of the grounds referred to in clause A and B, give the authority, a person concerned, an opportunity for an explanation. Thereafter, my lord, kindly come to 205.
Yes.
It says, my lord, no act done or proceedings taken under this regulation shall be questioned on the ground of merely of the existence of any vacancy in the so and so on account of so and so or irregularity not affecting the merit of the case.
It is affecting the merit. Others are being restrained, others are being, they are not.
No, my lord, it is on the basis of a circular. It is not, I have been given appointment without adhering
It's a
to.
different issue. This is 205 is not applicable. That's what I see.
No, my lord, it says if 205, my lord,
This
sees
is
one.
not affecting the merits of the case, but this definitely affects the merit,
The promotion.
the extension.
No act done or proceeding taken under this regulation. My lord, the proceeding I am of the resolution which has been adopted. No act done or proceeding taken under this regulation shall be questioned on the ground merely of the existence of any so and so or irregularity. Now, my lord, my argument by taking the aid of this section is that and a resolution was adopted. They have taken a decision. You say that it is an irregularity. Therefore, it cannot be given effect to. I say that you cannot do that in terms of section 205.
You cannot do that unless it affects the merits of the case. So it will definitely affect the merit of the case because the other candidates are being deprived.
No, my lord, it is on the basis of a circular. My lord, kindly have a note of this. As per the recruitment rule which the administration want to introduce, there was no avenue for promotion. No avenue for promotion. Now, my lord, the municipal authority and autonomous body taken a decision that instead of direct recruitment, it would be by promotion. That resolution was adopted. And on the basis of that resolution, a circular was made by the authority whereby they invited application or to fill up the said post on the basis of promotion from the persons who are eligible in terms of the proposed recruitment rule. And only after that I was appointed to the said post. So, my lord, the decision which has been arrived by adhering to all the requirement in terms of the law, that only on the basis of an irregularity, so-called irregularity, that the approval of the administration was not taken. My lord, I am an autonomous, the municipal authority is an autonomous body. It has the power to take decision. There are elected representatives. A resolution was adopted. They decided that we are going to do in this pattern. Now, only the approval was not taken. For that, the entire process adopted by an autonomous body within the four corners of the regulation cannot be set aside, my lord.
Let us hear the administration.
My lord. And my lord, I will just place that judgment, though it is not binding, at the cost of repetition, I am submitting, my lord. I will just.
Well, I will go through it.
My lord.
You have it today?
Today, right now, I don't have, my lord. I can give it immediately after the matter is over. I can give the server copy.
Because he needs to see it.
My learned friend is appearing, my lord, in that matter. My learned friend has. I will give a copy to him also.
My lord, may first have the letter of appointment of 10th October 2011, which is at
Yes.
page 43 of the writ petition.
Yes.
My lords, may firstly note, my lords, that the appointment is purely on ad hoc basis and for a period of 6 months. And my lords will further see point number 3. In respect of service matter not specified above, he will be governed by the relevant rules and orders in force from time to time as applicable to similar category employees of the council. So his appointment, and furthermore, point number 4, ad hoc appointment will not confer any claim, privilege or right for regular appointment. So at the time of entering into of this appointment itself, my lords, he was well aware that, my lords, that this is an ad hoc appointment. And furthermore, this has to be read with the advertisement itself at page 42. Kindly have page 42. And as the circular itself says, post of accountment and divisional accountment, which will be filled up as per the proposed recruitment rules. So he's aware that this recruitment rule is not a, published recruitment rule, but it is based on a proposed recruitment rule. My lords, these are educated people, my lords. Accountant, you can't assume that he's ignorant or is not educated. Now, my lords, page 43 again is appointed on ad hoc basis, and it is and his appointment has to be in accordance with the recruitment rules. Now, likewise, page 44, his extension order also says till a legal opinion is received and decision is taken. So, my lords, this further extension also he was made aware that a legal opinion is.
So what is this legal opinion about?
My lords, this, my lords, we'll have to, I don't know, my lords, I'll have to take instructions. Whether this legal opinion.
I mean, it's vague.
It is vague, definitely. My lords, after this, my lord may have page number 47.
Yes.
Which is the impugned order. Now, what is being done, my lords, my lords may appreciate that this person is an employee of the administration. No, he has a substantive post. He was given ad hoc promotion. Now, this ad hoc promotion was extended from time to time. Eventually, the recruitment rules were framed, and his appointment was not in terms of the recruitment rule. It is not merely a question of approval. The recruitment rule requires has a certain rigor, and he does not meet that rigor. So the published recruitment rules, which was of course subsequent, he was appointed on the basis of proposed recruitment rule. But when the recruitment rules were ultimately published, he was not meeting the criteria.
That's not the ground taken.
That is also. Kindly see.
My lord, no recruitment rule.
Kindly see.
Till date, my lord.
The ad hoc, kindly see, my lord, may see. Whereas page 47, Shri Sundar Rao, computer assistant, was given ad hoc promotion to post of accountant in PBMC. Whereas the said ad hoc promotion was extended from time to time with a different orders. Whereas the recruitment rules for post of accountant were in the official gazette dated 22nd January 2011. My lords will see to classify it as a group B post and provides for direct recruitment only as method of recruitment. So as per the recruitment rules, my lords, it is direct recruitment which is the method.
22nd January 2011 cannot be a recruitment rules because it's prior to.
It is prior. It is prior.
Yes.
Despite that, the resolution
So
was
the proposed recruitment rule, not the.
no. The
published,
recruitment rule was in place, but my learned senior had shown the resolution passed by the council.
Because even in September 2011, they say it's proposed recruitment rules.
No, yes, my lords, because he was appointed based on a proposal of the council to relax the eligibility criteria. My learned senior had shown the council's resolution, where the council had resolved that they will provide this as a promotional avenue, but that was not in terms of the recruitment rule. So it is an illegal appointment, irregular appointment on the very first day.
42 says it is as per proposed recruitment.
Yes, my lords, because my lords, we just see the 20, my lords, we just see this, what it says. This says from point number 2, in case of recruitment by promotion, deputation, transfer grade. Promotion from amongst serving higher grade clerk as computer assistant with minimum 10 years. So, my lords, the 22nd January 2011 is the official recruitment rule. The official recruitment rule said that direct recruitment is the method of appointment.
Where is
Then
that?
the council, it is also annexed. My lords may just see. It is annexed with the affidavit in opposition. My lord may just have the affidavit in opposition at page 46. And
This
his,
is a draft rule. This is not a recruitment rule,
no, 22nd February 2011.
draft rule. Because suggestions and objections have been invited.
No,
Till
22nd
date, my
February.
lord, no rule is
No,
framed.
kindly see this, madam.
Yes, page
This is
46.
published in the official
Second
gazette.
paragraph.
It's a
In
draft.
exercise of powers conferred of the supervision of earlier recruitment rule, Lieutenant Governor hereby proposes to make the following rule.
It's a proposal.
So in any event, this is 22nd February 2011. And my lords will see this, this refers to 22nd January 2011. So my lords, there is a prior recruitment rule, my lords, which is,
After that, how can there be a proposal for a further rule?
no, this was proposed to be amended, my lord. So this, as per the existing recruitment rules of 22nd January 2011, the appointment had to be based on direct recruitment. However,
Where
my
is that stated?
it is stated in the impugned order, page 47.
No, how? Based on what?
22nd January 2011, that recruitment rule has to be filed, my lords. I don't think it is on record.
Where is that?
I just check, my lords, if it is on record. My lords, in the affidavit in opposition,
Yes.
if my lord sees page 10. This is again, here it is saying
Page
that,
10.
yes, madam. Para 11, it is submitted the recruitment rule for the post of divisional accountant, commercial accountant and accountant was published in official gazette on 22nd February 2011, where method of recruitment was direct recruitment under schedule 11. So my lord, what is annexed is again a draft recruitment rule.
Yes.
This is an aspect which needs to be clarified, ma'am.
And in terms of this, the appointment was given. The proposed recruitment rules.
No, here it is direct recruitment, my lord. This is subsequent to his appointment. This provides for direct recruitment. So how can he is a promoting? It says it's pending for finalization with administration. So my lords, in any event, my lords, the point is, my lords, in terms of the impugned order, my lords will see approval. The other reason is that the approval of the administrator was not obtained. So my lords, it is an ad hoc appointment. So my lords, the ad hoc appointee is aware that, my lords, it's a 6 monthly basis. It is extended from time to time, subject to the rules. So my lords, in my humble submission, my lords, an ad hoc, I'll rely on a judgment also, my lords, in support of the proposition.
Ad hoc appointee cannot be thrown out.
No, he's not thrown out. That is what I'm
He
submitting.
is sent back to his basic.
He's sent
yes.
back. It's an ad hoc promotion. So
To the basic cadre, yes.
yes, he has been sent back to the basic cadre because his,
Without no reasons.
no, because my lords, the fact was that the approval of the administration was not obtained. Approval of the administrator was a prior requirement, my lords, which was not obtained. My lords, I have quoted the relevant. My lords, we just have page 22, my lords,
Of the
of the
opposition,
affidavit in opposition.
page
I
22.
just borrowed the regulation.
Yes.
Kindly see, my lords, as per rule 5,
Page
1, page 22. As per page 22 of opposition, as per rule 5.1 of the ANN Island Municipal Services Classification, Control and Appeal Rules 2008. All appointment to Group B post in municipal services shall be made by municipal council in accordance with notified recruitment rule, and each such appointment shall be subject to approval of administrator. And ad hoc promotion was not obtained the approval of the administrator. So, my lords, firstly, my lords, the administrator's approval was not obtained. Now so therefore it was an irregular appointment. Now, my lords will see the regulations themselves, where regulation 5 to begin with. Regulation 5 of the Andaman and Nicobar Islands municipal regulations.
Regulation 5.
5, my lords. Not 5, my lords. Let's see 197. 197 first. 197, 198, and 205. 197, my lords.
Yes.
One 197, controlled by the administrator. The administrator and the deputy commissioner acting under the orders of the administrator shall be bound to require that proceedings municipality shall be in conformity with law. Administrator may exercise all powers necessary for the performance of this duty and may, among other things, by order in writing, annul or modify any proceedings of the municipality which he may consider not to be in conformity with law. Then likewise 198. The administrator may, by order in writing, suspend or cancel any resolution passed or issued or license or permission granted or prohibit the doing of any act which is to be done or is being done in pursuance or under color of this regulation, if in his opinion such resolution, order, license, permission has not been legally passed, issued, granted, or authorized, or such resolution, order, license, permission, or act is in excess of the powers conferred, or the execution of such resolution, order, continuance in force of such license or permission is likely to endanger human life, etc., provided shall, before taking such action, give the authority or person concerned an opportunity of explanation.
Was
Now,
that given
no, my lord, this.
an opportunity of explanation?
No, my lords, but this is a decision of the council, my lord, and this is only to show that the administrator has this is just to show that this read with Rule 5.1 of the ANN Islands Municipal Service Classification, Control and Appeal Rules 2008. This is only to show the control of the administrator. I am not saying that the administrator has passed an order. The council has passed an order saying your appointment was irregular because prior approval of administrator was not taken. Now 205. Which my learned senior had read, no act done or proceeding taken under this regulation shall be questioned on the ground merely of existence of any vacancy municipal subcommittee on account of any defect or irregularity not affecting the merits of the case.
Yes.
Now, this is something which definitely affects the merits of the case because, my lords, the appointment itself is irregular. So the appointment becomes a nullity in the eyes of law. Now, my lords, we next see what is the nature of the ad hoc appointment. My lords, I am relying on the Supreme Court judgment in the case of Uma Devi, my lords. I would just like to read 2 paragraphs. I have 1 copy. I'll hand over the judgment after reading. My lords, we see para 47 of Uma Devi. When a person enters a temporary employment or gets engagement or as a contractual or casual worker, an engagement is not based on a proper selection as recognized by the relevant rules or procedure. He is aware of the consequences of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory or legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following proper procedure for selection and the cases concerned in consultation with Public Service Commission. Therefore, theory of legitimate expectation cannot be successfully advanced by temporary, contractual, or casual employee. It cannot also be held that state has held out a promise while engaging these persons either to continue them where they are or to make them permanent. The state cannot constitutionally make such a promise. It is also obvious that theory cannot be invoked to seek a positive relief for being made permanent. Now, 48. It was contended the rights of employees thus appointed under Article 14 and 16 are violated. It is stated that state has treated the employees unfairly by employing them on less than minimum. No, this is of course not relevant. So, my lords, may then just come to Classitum C. There is no fundamental right in those who have been employed on daily wages or temporarily or on contractual basis to claim that they have right to be absorbed as held. The court cannot be said to be holders of a post since a regular appointment could be made only by making appointments consistent with Article 14 and 19. The right to be treated with So my lords, my only reliance on this is to say that my lords, as an ad hoc employee, as an ad hoc employee, the petitioner was aware of the nature of his service, which was extended on 6 monthly basis. So my lords, today the administration took a decision not to extend his service beyond 6 months. So technically, he is questioning the fact of taking away of his ad hoc promotion, whereafter he has been again reverted back to his
The grounds. He's
The ground-
questioning the grounds.
Yes, my lords, but it was up to the administration also not to extend it further. It is not necessary, my lords, that the ad hoc promotion does not give him any right. It is only an ad hoc promotion. So, my lords, it has been taken back. So, my lords,
It should be a speaking order.
Yes,
You
my lords,
only
that
say
is
it's
true,
irregular. Irregularity can be regularized post facto. It's not illegal.
my lord. And lastly, my lords, I appreciate, my lords. Lastly, my lords, I would like to place the order of the interim order dated 9 January 2018 passed in this matter. My lords, the learned predecessor bench is also considered, my lords. It is not, my lords can consider the view, my lords. I'm only submitting my
Order dated
9 January 2018. Passed in these very proceedings. My lords may kindly have that the petitioner has challenged an order dated, my lords, has 9 January.
yes, yes.
Petitioner has challenged an order dated 27 December 2017, by which he was reverted to his substantive post with effect from January 1st, 2018. The order further records that the municipal council in its last meeting held on 27 December 2017 had decided not to extend ad hoc promotion given to petitioner. This is important, my lord. The order records that municipal council in its last meeting had decided not to extend ad hoc promotion given to petitioner beyond 31st December. It may be mentioned that petitioner, his computer assistant of the municipal council Port Blair, was given ad hoc promotion to post to accountant by an order dated 20th October. And from time to time thereafter, this ad hoc promotion was extended. The order impugned records that in the present case, the notified and published recruitment rules for the post of accountant have been violated in as much as in terms of relevant service rules or appointments to Group B post. Post of accountant is one such shall be by in accordance with the rules and that shall be subject to approval of administrator. The order further reveals the approval of administrator was not obtained for ad hoc promotion and municipal council considered the petitioner's promotion to be irregular. I have heard Mr. Kumar, learned advocate. Mr. Kumar has stated that since the petitioner has been working as accountant on ad hoc basis, he may during pendency be directed to work in the post he was holding before his reversion to substantive post. This, however, is not a fit case for grant of mandatory interim order. The order has already been taken effect with effect from January 1st. Petitioner has not satisfied as has been settled numerous essential precondition for grant of mandatory interim order. By the time the order impute had taken effect, that is what direction or irregularity in ad hoc promotion, even if belatedly detected, is a factor prima facie operating against prayer for grant of mandatory interim order. Moreover, balance of interim relief was rejected, my lords, on a prima facie basis. My lords, these are my submissions, my lords.
Will you come back with the judgment on Monday?
My lord.
Let it appear on Monday.
My lord, I will just, whatever my learned friend has said. My learned friend, my lord, first of all, at no point of time, there is any notified recruitment rule under Article 309 of the Constitution of India. Whatever document is there, that it is only an executive fiat. Now, my lord, thereafter, and my learned friend has submitted that he is the staff of administration. I am not the staff of the administration. I am working under the PBMC. My lord. Thereafter, my lord, so far as this interim prayer, my lord, that was because already the order was given effect at that junction. That's why the court did not interfere with. So that's entirely different, my lord. Today, after pleadings, we are before my lords, my lord. So I will just place the judgment on Monday and I will serve a copy to my learned friend today itself.
Earlier,
Yes, today itself, my lord.
For learned counsels for the parties. Let the matter appear under the same heading on 16th. Shall we continue further? Yes.
Let it be for the day. We did not have the light.
Are you ready in the other matters, next matters?
We are otherwise ready, my lord, but we don't have our lunch, my lord.
Oh, I'm so sorry. Well, Monday.
My lord.
Difficulty is actually there was a request from the bar not to sit after 2 p.m. So I thought let me continue till.
My lord,
2
my
p.m.
lord, my
at
lord,
least.
my lord.
So if that's difficult for you, I can sit at 2 p.m. if you want to. It's absolutely up to your convenience.
If
If you
Mr.
think that-
Chakravarti is there, my lord, I am always,
He's at 1:30 and come back at 2, I can do that.
my lord, Mr. Chakravarti must be available, then only.
Well,
matter
I
will
am,
be
but
taken.
my lords, the leaders of the bar, like.
No, my lord, I am ready with all the
I have
matter.
to
But
decide.
he has a request from the bar, actually, because.
Yes,
it's
madam,
the
which is why,
same
my lords,
setup-
I am not,
The same setup.
like seniors, sir.
due To the district courts also.
yes,
So there
madam,
was-
I understand the difficulty.
Early morning, we deal with the lower courts as well.
That's the reason why I was requested not to sit at.
My lords, it has to be a collective, my lords, because otherwise it
So
can
that's why it's absolutely. up to
cause
the
inconvenience to
convenience.
the other members of the board.
So I'm ready for everything. and convenience.
My-
Practice that. We have a lot of pressure like that.
Since both the courts are closing down for vacation, anyway, we'll continue like this then.
My lord. Only Monday, Tuesday, I have indicated, my lord, some personal
Yes,
difficulty,
yes,
he'll be here.
yes, yes.
Charges.
Very good. Absolutely. I'll be there. I'll be there. No difficulty. Absolutely.